What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey everybody, we are here. We are back. Let's jump straight into this. Brice Rhodes, day 5. The judge is just telling us why one of the jurors will not be here.
Wouldn't be able to be here today.
He's in the hospital.
Excused him from further service since we have 3 alternates. So
let's readjust the microphones.
Is there anything else we need to take up? Here's what I'm thinking. We'll see how far we get in your proof today. At some point, let the jury go, talk about instructions, and see where we'll be tomorrow.
Oh, God.
And Judge, I know they're not here, but I feel better approaching. If we could approach.
Wow. Okay. So it looks like the defense is going to put on their entire case today, and they're looking forward to instructions tomorrow. All right. Fair enough. While they're doing their little sidebar thing, good morning, good afternoon, good evening, everybody. How are you all doing? We are here. Ooh, Law and Crime got a new thing. Check that out. They got a new thing going on over there. We may have to embiggen the cut cage. Huh. Dang. All right. Well, look at that. It's all fancy and new. Why is there an American flag backwards on there? Is that the court or is that on the stand, the backwards American flag? What the fuck? That's weird. All right. Huh. Oh, okay. So it seems like that backwards flag is on his desk. Oh, my Lord. He's put a backwards flag on his desk. America in crisis. I'm being tried. I'm being tried for triple murder. America is in crisis. It's in danger. Because that's what flying the flag backwards essentially means. If you backwards or upside down, it's kind of the same thing. Yeah. It. So if you ever see the flag upside down or backwards, it's protest, crisis, whatever. It's just anyway. Well, no, the backwards flag is definitely intentional. I know it's a military patch. But do you think he's in the military? In the military, it's the flag waving backwards as you go into battle. Unless that's what he's insinuating. I don't know. Let's not try to figure out what's going on in the mind of Brice Rhodes. It's a scary, scary place.
So we are going to actually go ahead and argue instructions. So I'm going to tell the jury what's going on. Okay, perfect. And I'm not actually going to come back and get it.
Yeah, Flux, I'm just saying, are you thinking that's what he is intending it to mean, or he's a goof. All right, they're talking to somebody back there, but hey, let's get through a couple of these things here. Phoenix Fire has been a member for 5 months. That is so awesome. Thank you so much. And Angel Australia, yeah, caught you live. Yeah, this is the afternoon session. They had no morning session. We don't have the option of fast forwarding through anything. We are real time. And Chris Rowland, member for 1 month. Happy National Baked Cookies Day, US. Be sure to smash the like button for the one and only
So when we
Lorax.
were here last week,
And Bridget, any
I
thoughts on the
indicated
verdict?
to
Seems
counsel
weak,
for
except for the
both
second guy who
sides
pled
that
guilty.
generally with
Thoughts? We'll
instructions,
give the thoughts on the next break.
what I will do is look to see where they're different and go through them that way. However, because I did not get instructions until this morning, I have not had time to do that. So, you know, I'm just going to kind of go right into it. All right, let's look at the Commonwealth's instruction with regards to presumption. I'm sorry, the defendant's instructions with regards to presumption of innocence. Is there any objection to that inclusion?
Why is she wearing a camouflage thing?
It appears to me to be the standard Cooper's instruction for presumption of innocence. It's this. I'm looking at the defense's version of instructions, their first page of actual instructions.
I have it under instruction.
Oh, do you?
The jury's not there. She doesn't
And
have
so
to get
then
all
does the
gussied up
defense
yet.
have a position on whether it comes before or after the instructions as to the various counts of the indictment?
Judge, I don't know that the court is compelled to do it one way or the other.
It doesn't matter to me.
It's our preference that it go first.
Okay. And then the Commonwealth also included a definition for unanimous verdict. Do you want that included as well?
Do you need a definition of the unanimous
Remember,
verdict?
I thought I did have that.
Maybe you
Doesn't
have
it just
at the
mean
end.
unanimous verdict?
Right
That's
before
fine.
the-
We'll just continue going through yours.
Oh yeah, voice is like 99%
All right,
back.
definition.
We just need a little more bass in it, and we'll be back to where we were. But we're
you
by and
aware of any
large
differences
back.
in your tendered definitions?
Yes, there are a lot. The
Oh,
Commonwealth is
See.
only asking for an instruction on intentional murder. So that cuts out a lot of the definitions that we submitted. We submitted on definitions on intentionally, complicity, and civil proceeding.
For the defense,
Judge,
what is the basis
Just
for
zoom me in
including
here a
wantonly or recklessly?
well, Judge, the indictment says wantonly in it on all three of the murder counts.
Mhm.
So based on the actual charges themselves, we thought that it should be there. There wasn't any amendment, nor do I think that we would object at this point to an amendment of the indictment or of the charge.
we need to devise a new cup cage.
I don't think recklessly is in
escaping.
there.
No, I was
Okay. Okay, but just
specifically
for
referring to
wantonly.
wanton.
Okay.
Their new
Judge,
logo
we
is
are
escaping the
asking
cage.
For lessers, and I don't know if the Commonwealth appears not to have proposed those, but it is our motion as part of our proposed instructions to ask for lesser included, which would include manslaughter in the first, manslaughter in the second, reckless, which are the standard lessers on any homicide, and then also based on the evidence that's been presented, as well as the
Island is a new member. Thank you so much, Eileen.
Co-defendants, we believe facilitation.
Clean
would
and
be an
sober
option
crew.
For the jury.
All right, just a moment. So as to wantonly, I think based on the charge, wantonly should be included, but does someone have any objection to the wantonly definition being included?
We do, Judge, because there's been no evidence presented at trial that would support anything but intentional in this case. I realize their defense is that he is not the one who did it, but the evidence at trial is that these.
I'll let the jury decide.
Can I
the
tell you what
evidence
my concern is? My concern is that without wantonly, the jury would not be able to find that even if the purpose wasn't to intend to kill, that it doesn't fit under intentional murder instead of wanton.
If the court is going to give a wanton murder, then we would request that it be a combination instruction. as is allowed under the law.
Can you tell me what you mean by that?
Can you
I'm
tell me what
sorry,
you're
an
talking about,
instruction that
prosecutor?
on one page says.
Oh, yes, that's what I'm
intentionally
talking
and
about.
or wantonly.
Okay, big girl.
That's what I was referring to
Don't
as the
scream into the
indictment
microphone.
reads.
Yes. And the courts have commonly found that throughout the years. that
Don't
that
use
is
your
part of
lungs if nobody else is
instruction,
using theirs.
and that it is proper for a jury to find, if they are considering intentional and wanton, that it could be under the facts of the case, that some could find intentional and some could find wanton, but it is still a unanimous verdict.
Judge, we respectfully disagree with the Commonwealth under the facts of this case. One of the issues, Judge, the Commonwealth's proposed instruction does not have that. We did propose a separate wanton murder instruction, but the significance there is that the penalty results would potentially be different. So for a jury to reach a conclusion and have us not know whether they found it to be intentional or wanton prevents us from knowing how to proceed in a possible penalty phase. And I can go into more detail about why.
I mean, it doesn't. It might change your strategy, but it certainly doesn't prevent you from being able to do that.
Judge, if in fact the jury found guilt under wanton murder instruction, then it would no longer be an aggravated murder, and therefore two of the possible penalties would disappear. So that's a pretty significant difference.
Is that correct? I didn't think that was true. If they found wanton murder, not manslaughter, not just wanton murder.
I believe,
Wanton,
Judge,
not
that under
wanton.
the
Wanton murder.
aggravating statute 532.025. I'm going to pull it up, but
Thank
I
you.
don't expect you to take my word for it.
No, I do understand that you know what you're doing.
That the aggravating factor.
I don't know.
requires,
He's not the greatest. He's not the
multiple
sharpest
murders
tool
that
in the
are
belfry
intentionally
there.
committed.
I see. 532.035 is repealed. Ms. Jones Brown? Oh, you're looking too? Okay.
So it's 532.025 2 for the specific one.
Thomas
Sorry,
Haberling, is this really where we're going today? It's 2:30 in the morning here. I can't.
Well, to that, I would say, Judge, that the law does allow accommodation instruction. I understand their point as to penalty. I would think that a way to cure this would be to ask in penalty, like to make that part of the penalty phase instructions if we get to that point, so that they
Yeah, we've
cannot
done that
impose
before.
the aggravator unless they have found that it was intentional.
It seems like it's inviting confusion, Judge, to give them an instruction that defines murder and the actions in one phase one way, and then defines it differently in the second phase.
Well, it's not defining it differently, it's just splitting up the definition.
Splitting up the definition of murder.
We're comfortable with that in the second phase. I don't see why we wouldn't be comfortable in the first.
To split up the instruction invites the possibility that you could have 6 jurors who believe this was an intentional
Wait.
murder. 6
No,
who believe it
where'd
was a
the
wanton
comment
murder.
go?
Neither of the
Defense
they're not
attorney has his
unanimous
pants tucked
on
into his socks. Yes,
either
his
count one
left
or count
pant leg
2 under
is
the
tucked
proposed
into
instructions. Therefore,
his
they
sock.
can't sign either of those jury forms, but all 12 believe that
Oh,
this was
no.
murder. That's not the state of the law. The state of the law is
Oh,
that
no.
it is a unanimous verdict, even though some might think intentional and some might think wanton.
And we would respectfully disagree that that would be appropriate under the charges in this case, and specifically.
It's just right there, tucked right into his sock. Oh, God. I can't do
I can say, Judge, a lot of courts do give, the separate instructions just for the clarity, just so we all know.
And the Commonwealth objects to like intentional or wanton.
I mean, it is our
Separate
preference that
instructions.
this just goes forward unintentional. But I understand what the court's saying, so I'm not objecting to the wanton. I am just asking for it to be a combination instruction, and then on penalty, they would have to find beyond a reasonable doubt that these murders were intentional to get the two aggravated possibilities.
That is, in fact, how we did it last time, and there was just a case published that talked about that being appropriate.
I apologize.
We did that for like, are you finding it to be a violent offense?
Get some oxygen there, Judge.
I see the analogy, though I don't know that it necessarily is controlling in our case, Judge.
No, I understand. All right, I'm going to come back to I'm going to do one or the other. I'm either going to do a separate instruction for wanton or combine it, and then to the jury to make a finding and sentencing as to intentional or wanton. Let me come back to that after we've talked about other lessers.
Yes, Judge.
The defense
All
lawyer,
right,
he's a
so what
lesser.
is the defense's position as to why a facilitation charge should be included?
Judge, I believe that the evidence itself has, the Commonwealth is asking for a complicity instruction. And if we look at the definition of complicity, which we included in our definitions, and the definition of facilitation, you can see how in any complicity case, facilitation is raised. And in particular, in this case, there has been more than a little bit of evidence suggesting that Mr. Rhodes may have been present and may have
Oh, that's
participated,
interesting.
but may not in fact have been the one who caused the deaths. And that is classic facilitation.
That's interesting. He's asking for an
Commonwealth
alternate
has sort
charge of facilitation. Facilitation.
Trail for us by
Saying he
the
may have
manner
been
in
there, but
which
he
they
didn't do
dealt
it.
With two
Interesting.
co-defendants, where they concluded that in fact their actions, even though they were involved and present, merited a facilitation result. It is our position that the facts as presented at a minimum allow the jury to potentially reach that result for Mr. Rhodes.
Okay.
The Commonwealth objects, Judge. The way that the Commonwealth and various defense counsel choose to settle co-defendants does not then bind this court who sat on this trial and heard this evidence as any certain theory.
This might be
There has been no
4D
evidence in
chess.
the case that the defendant was present but didn't do anything and just allowed it to happen. The evidence has been, this is sort of an all or nothing. He either
And see, that's why I'm thinking this might be
directly involved
4D
this
chess.
and participating in this, or he wasn't.
He's saying, look,
So
they've charged him with
facilitation
doing
is more
it,
of a disinterest in the outcome.
but he may have been there and facilitated,
Complicity,
Ja'Cory
is
or
engaged in
Anwan may have facilitated one of those two in committing the murder. So we'd be willing to take a facilitation charge as well.
Judge, if the Commonwealth thought that the
But
only
the
issue on
Commonwealth
table
is
was
saying,
all or nothing,
No, we want all or
where
nothing.
Mr. Rhodes had
So he may
actually
have given them a
reacted,
bone, which they
complicity was
yank out
part
from
of their
underneath him. And then if the jury
instruction,
says,
part of their indictment.
gee, he may have been there, but he didn't do it, a la my personal feelings about OJ. He may have been there,
I
but he
don't
didn't do
believe
it,
that
but he
there
helped.
has
We got to
been,
let him go because he didn't cause
any
the murder.
evidence
This
put
may be 4D
forward
chess, but I don't
other
think
than a
they're
theory
that deep
where
in that.
this was Brice Rhodes' idea. So I don't think a facilitation instruction is appropriate. In that case, because of that, and because I just don't believe that from the evidence that's been presented, any juror could find that Mr. Rhodes' actions were facilitation. I think he's all in or nothing on that.
Judge rejects it.
I'm going to deny that instruction.
That may have been some 4D chess. I'm not actually thinking so, but it may
First
have
degree
been.
manslaughter.
We believe that the evidence.
First degree
reasonable juror could
manslaughter.
conclude that there was an intent to.
Not feeling that
injure,
one.
And seriously injured, as defined by the statutes, without an intent to kill. which
If
is
you stab someone 12
classic,
times, I think it goes beyond manslaughter.
result, Judge.
And can you tell me any particular evidence you point to in reliance on that?
Yes, Judge. And again, we're talking about the role specifically of Mr. Rhodes, the discharge under the evidence of what appears to be a single shot is not necessarily an intent to kill. That's in any way.
He shot the guy in the chest, but didn't intend. Shot a random guy on the street in the chest and didn't intend to kill him.
I don't think that that's sufficient to necessarily automatically amount only to murder charge. And as far as Maurice, am I right?
He doesn't even sound like he's trying to convince
And
himself.
as for second degree manslaughter, same question.
He's like, I don't even
Judge,
believe what I'm
we
saying right
believe
now.
That the Commonwealth's indictment listed wanton murder, and the court has indicated the intent to go forward with instructing the jury on wanton murder. Manslaughter in the second degree is almost identical to a wanton murder and is contained within a wanton murder. The difference is what is the additional element of manifesting extreme indifference to human life. That is a nebulous concept.
She's been invited. She's invited all the time.
Than us. And I believe that if a reasonable juror could find a wanton murder, that same reasonable juror could find manslaughter in the second degree.
Commonwealth, what is your position on both first degree and second degree?
Judge, I don't think that there's been any evidence in this case that would allow a first degree murder. The evidence that has been presented is that the intent in going to 41st Street was to kill somebody with a price on his head. That he stated, the evidence is that he stated that intent to the witnesses as they testified. He shot a man. They've already got the wanton instruction, which I think covers whether it was an intentional or just something that we in the court under these definitions consider wanton. There's just no evidence that he intended to shoot but not kill him. As for the second degree, I think that once you give a wanton murder, you have to give a man too. So I'm not contesting that one if there's a wanton given.
Okay. All right, so that's here.
I might be wrong about that, but I feel like there was a case a couple years ago.
I wish other people could do their sites like that. I'm not sure, but I think there was a case about that a couple of years ago.
I feel like the instruction's wonky though.
Unintentionally so, Judge.
I know.
Just one.
I'm sure.
And I have a copy of Cooper's that is.
I've got it.
There's another instruction in there that says and wasn't. It has the optional and wasn't in self-defense and stuff like that. But that's in the plan.
Actually, Judge, in Parker versus Commonwealth in 2007, so this wasn't even recent. With the wanton murder instruction should come instructions on lesser included offenses, notably here an instruction on second degree manslaughter.
Does somebody have their phone playing something? I keep hearing some like video playing or something.
Oh, the judge is hearing voices. We're in trouble now. Uh-oh. She's probably hearing his rap songs in her head. I think at some point in effing Friday, my camera got tilted up a bit. Or down, whatever.
Yeah, it was just I was just looking at the wrong one. Okay. So I think that the second degree one, the way it's written is fine. So shooting him with a firearm and acting wantonly, it does match up perfectly with Cooper's. I was just looking at the wrong thing. Sorry about that. Okay, in reading the second degree manslaughter instruction.
His prison purse is ringing.
Well, let me also hear any arguments regarding the reckless homicide and what evidence you believe supports a reckless homicide instruction.
I'll be honest, Judge, I didn't read any case law that required it. I'm used to it being given when a man two has been given. Usually they sort of go hand in hand. They have a lot in common as far as the mens rea and issues like that.
Mens rea?
So we proposed it.
No!
I'm not aware
My
of
God!
And we think it would still be appropriate along with the same argument basically as the manslaughter in second degree.
Unless the Commonwealth wants it included, I'm not included. I'm going to allow it. Okay, I'm going to deny that. I don't think the evidence supports that. And then that also means that I'm looking at removing recklessly from the definition.
No, defense hasn't done their thing yet. Defense hasn't done their thing yet.
The definitions for the defense, Judge, I think you had excluded manslaughter first, which means EED shouldn't be in there.
I did not include
They're just getting
manslaughter
the jury
yes,
instructions
okay, thank you.
underway, so they can get straight into them tomorrow, apparently.
Facilitation can come out. Well, I guess I'll come back to that because we haven't gotten to the other instructions. I think that's it for now. Okay. All right, let me not get these all out of order. I really wish these were page numbered.
I'm sorry.
It's okay. I just might.
But if the page number
Lose
doesn't
track.
take one out, then we're all confused because the page.
All right, well, she's rifling through papers. Let's try to clear some of these comments here. Wow, okay, you've changed it. Psychedelic X. Member for 4 months, been mooching the gifted membership for 4 months. Also, this is not a little late night, early in the morning for you. It is 2:30 a.m. Well, now it's 3:01 a.m. We started at 2:30 a.m., but I slept for like 6 hours before, so we're cool. Island, we congratulated you as a new member. Julie O with a $5 super chat. Thank you so much. Catching up, my hometown had a person climb the water tower and paint an upside down flag one night. It was huge too. Glad to learn them. And JKD Bug, glad your voice is back. La Rex, best channel on YouTube. Don't on YouTube. YouTube.
After the reckless homicide and
don't know I'd go that far, but thank you anyway.
Is it more? Is it like another presumption of innocence, or does it go straight to intentional murder?
I think you go straight to the next count, Judge.
Okay. And that is the intentional murder as regards to Maurice Gordon.
Oh, so all of that was just for the driver, just for the drive-by guy. Wow.
On the reckless homicide, since I'm not allowing it, I think that because there is going to be the second degree manslaughter charge, to me, it makes more sense to have one instruction for intentional, one instruction for wanton, one instruction for man two. So that during closings, you're able to explain to the jury what the differences are.
I agree with the court.
Rather than trying to explain those differences later. If it was, if we weren't also having the second degree manslaughter put in there, I think I would think a little differently about it, like decide later. But I think as long as they're going to have to decide for one act and then act two and then act three, for as long as they're going to have to decide each one already, why not just have them go ahead and decide it based on a separate instruction for each one?
And this might not be the case where it really matters, but theoretically in a case where a jury is having trouble deciding intentional or wanton, how does that scenario account for the fact that they are allowed to convict on murder even if they disagree on the theory?
Mm-hmm. Yeah. Yeah, that's a good point. You all want to add anything on that for the defense?
Judge, I think that's raising an issue that is an unlikely event. I think the more
Famous last words.
Yes,
Dr.
Judge.
Gervais.
I think the more likely result is we understand these. Hopefully, we understand them pretty well, right? I think that they're confusing to the average person, and setting them out with separate instructions is just a lot clearer to the jurors and makes a lot more sense to the jurors.
It might, and I understand that, but I agree with the Commonwealth. I think it's too great of a chance of them not understanding and not knowing. If some of them think it's wanton and some of them think it's intentional, we'll be in a rough spot.
Would that be? Could that be resolved by an additional instruction or an admonition?
It could, but I don't really see the point of that. But I guess the question for me really is, should we have a separate instruction after that? Like, if you have found the defendant guilty under instruction number blah, 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 do you unanimously agree it was intentional? And go ahead and knock it out prior to sentencing.
I think that would. I think that would work, Judge. I think that would fix it.
All right.
So
Then I'll go back and look at that other one we did for how we put that in there, and I'll let you all know what it is.
Okay. And would that then go sort of near the end? Last one?
It'll be like the intentional or wanton instruction, and then the next one, if you found guilt under the last instruction, and then the language, do you believe it was wanton or intentional? And then very next thing, if you did not find the defendant guilty under instructions 1 or 2, you may find him guilty under instruction 3, if and only if for the second degree manslaughter.
Are these going to be numbered like 1A, 1B for?
That's the door to her chambers.
Yeah.
Christopher Jones.
Yeah, I'll
And
rewrite
the
them
outside
all.
of the court,
Mhm.
yes.
Yeah. And so, go ahead.
I was just going to say, we tried to do that. Like the ones I have at the back, Judge, are by count, and that may satisfy what the Commonwealth is talking about.
That's how I'll do them. I'll do them by count.
Yeah, 'cause I think if you do A and B, it helps the jury not.
For those of you joining, we've got 448 of you here. For those of you that have joined late, they're just going
All
through
right,
jury
let's move
instructions.
on, as to the count with regards to
Because
Marty's
after they
gardening.
finish the
Are
jury
anybody's
instructions, I
arguments any
guess
different?
the
If not, I'll
defense
just
is going to put on their
keep the
case
same on each
today,
one.
and they're expecting the
only different, I mean, the facts are different, obviously, Judge.
the jury instructions to be given tomorrow. Sounds like we're wrapping this thing up quick.
Those two are pretty much identical as far as the arguments go. There is additional evidence regarding actions of multiple people rather than a claim of actions of a single person,
Okay.
which I think would justify the facilitation instruction.
She already said you ain't getting the
I
facilitation
understand.
instructions.
Ms. Jones Brown?
I don't have any additional arguments to what I've already made.
Whatever, I don't
I
care.
would continue to object to facilitation.
So from my perspective, the testimony, there was not anyone whose testimony supported an idea that that Mr. Rhodes was facilitating someone else in committing those crimes. Can you point me to what you would rely on?
No.
The
Uh,
specifically, Judge, just the testimony that literally said things like everyone stabbed, rather than just.
Well, the testimony I heard was like, Brice made me also stab. Was there a witness who testified to something other than, being told to stab the person after they had already been stabbed?
Even the witnesses who testified that two other people that weren't here, that we never saw, one who was identified, one who was not identified, also were involved and also were stabbing. And both of the
so that's going to be okay. He's tipping his hand as to what they're going to probably talk about during their case.
stabbed both of the victims in count 2 and 3. So we believe that would also support a possible verdict of facilitation rather than.
Okay. I do not believe that any evidence that was produced would allow the jury to find Mr. Rhodes guilty of facilitation to murder or first-degree manslaughter for the same reasons, that there was not any testimony other than testimony that it was his idea, that he was directing the actions of others. Do we need to make additional record with regards to Larry Ordbay, or is it the same argument?
Same argument.
Okay, same ruling. And then we get to tampering. Are your all's tampering instructions the same?
They're largely the same. They just have evidence. I listed some items of evidence.
I don't. That's fine, Judge.
I'm relying on the case.
I wasn't.
Hackett versus
If that's
Commonwealth.
fine. That's,
Yeah.
I'll use yours as it is.
I do want to change, have an amendment to mine. I would like it to say and or instead of and. I believe that the jury could find any one item was tampered with.
Arguing over jury instructions is
Oh, you mean on the final
most
line
exciting
of
part of
A?
the case next to the actual jury instructions.
Yeah, I gotcha. And or the back seat of the blue must all allow
Actually,
that.
the actual jury instructions are more exciting than them arguing over them. So, yeah.
Okay. And then abuse of a corpse. Looks like they are largely the same, although the Commonwealth is a little more like fact, just barely a little more fact specific.
You don't object, Judge, to the Commonwealth.
Okay, we'll do that for each of them. Okay, so now we get to the other instructions. Let me briefly go back to definitions. So the Commonwealth's definitions are just intentionally, complicity, and official proceeding. For the defense, intentionally, wantonly, physical force, deadly physical force, serious physical injury, and complicity.
I think we can get rid of the serious physical injury. due to, that was for manslaughter in the first degree.
That's
Okay.
correct, Judge.
And so I think I could then just add in official proceeding. So the definitions would be for intentionally, wantonly, physical force, deadly physical force, complicity, and official proceeding.
I think that's right. I didn't put in official proceeding, that's my fault.
What is the physical force and deadly physical force from? Where is that?
Deadly physical force. You know, I think that might be from,
That might be in man one.
that's what I was thinking.
I believe that's why I put it in there.
No.
I think it's from extreme emotional disturbance. So removing that due to removing man one.
It is. It
What's
is.
the need for that?
Okay. So then add in official proceeding. Okay. All right, and then at the end of each individual instruction, the Commonwealth has presumption of innocence, which we're putting at the front. We won't need it there. Both of you have unanimous verdict. Let's see. Okay. So let's talk about this right to remain silent.
Okay.
Instruction. Any objection to that?
I have it at the end of presumption of innocence, but I don't object to it being separated out.
So it sounds like he's not going to testify on his own behalf if they're talking about the jury instructions dealing with he don't got to say nothing.
Then right to remain silent. All right. Let's go ahead and talk about the spoliation potential instruction. The defense is requesting a tainted evidence.
Oh, Aaron, there's no reason to go back to the beginning.
We believe that primarily applies to the car seat, lack thereof. There was a lot of testimony. There was admission by the police in this case that that they did say under oath on 2 occasions, as well as 4 years later, 3 years later, excuse me, in this courtroom, that there was a car seat, and it was included in the police report. And now, of course, the court is well aware we have not seen one, and they're saying that there isn't one. There's different versions of this instruction, Judge. This is the one that I put in. We wanted to change the language to missing. Obviously, that's fine with me too, but this is the one I thought best matched the facts in the case. It's frankly less confrontational in some sense. But so I chose a version and form that I thought would work better with the facts that we heard and the evidence in this case.
Ms. Jones-Brown.
Judge, the Commonwealth does object to this. The evidence, while it does show, I mean, the court's very well aware of what was testified to, and I think an inference or an argument on their part can be made to the record keeping of the police department or the procedures of the police department, or even if they want to shoot for the credibility of the lead detective, but there is no evidence that the backseat was recovered and then lost. So we would object to this.
Yeah, well, there kind of is when the lead detective says unequivocally tells the grand jury they have the car seat. When somebody else says we have the car seat, and now they're saying we don't have the car seat. That's kind of evidence you had the fucking car seat. I'm sorry. Then you try to cover and say we never had the car seat. Well, that's on you. Maybe you shouldn't lie to the grand jury. Maybe you shouldn't put bullshit into a police report. Yeah, when you put in the police report, you got a car seat. When you tell the grand jury you got a car seat, you got a car seat. If you don't, it's on you if you can't produce it at trial. That's not an investigative technique. All right, let's go through some more of these. That dog in him has been a member for 4 months. Says I cannot see poll because YouTube is asshole. I blame Joe Choi. And is happening with Harper. Has been a member for 9 months. I only missed the detective that last testified. You missed the greatest witness. Go back and watch it, or at least watch the last hour and say 15, 20 minutes from last Friday. Do not miss. He's the problem in this whole thing. Definitely go back and watch that. If any of you have not seen the last, he was the lead detective that testified. He was the one that testified under oath that he lied to the grand jury. Lied. The police report was. Oh, we lost a subscriber, by the way. Someone in comments said they unsubscribed because I said that the lead detective lied when they didn't think he did. So somebody unsubscribed because I said the lead detective lied. So anyway, the lead detective lied to the grand jury. The police report has lies in it, et cetera, et cetera.
Here's part of the problem.
And he got his
Part of
ass
the
handed to
problem
him by the
here is that
defense.
I don't feel it was ever established whether a back seat ever existed.
They said they had it, Judge, under oath.
That's the problem I'm having, is that it is not as though
Fight for it,
we
defense
know,
lawyer.
A,
Fight
there
for this one.
definitely was this piece of evidence.
He
and
told the
B, that it
grand
was
jury
left
they had
left.
it.
I think it's statutorily they're not. If it did exist, it potentially could be a violation of the law if it was destroyed or not kept.
That's
If-
their
if it
problem, not
contains
yours,
bodily
Judge.
fluid.
That's not your problem, Judge.
KRS
They
524-140 talks about how if an item is found that contains biological markers such as bodily
Judge,
fluids,
that's not your problem.
it is a violation of the law.
Fight for this, defense guy. Fight for this.
Dispose of it. The problem is, I don't really feel like it was ever established that it did in fact exist.
He told the fucking grand jury they had
The
it.
question to me, or it revolves around, the reason I submitted the instruction is I believe that the court and the jury are able to rely upon sworn testimony. And the officer in the case, Detective Tonelli.
A little more passion, guy. Come on. You got to be
Oath,
convincing here.
Preliminary hearing. He testified that there was one. He testified under oath at the grand jury that there was one. And then in this courtroom, 3 years later, told Judge Cunningham that the biggest piece of evidence that they had to bring was the car seat. And actually, he may not have been under
Absolutely
oath
right.
that third time, Judge.
And it doesn't matter.
It does matter, Judge.
But
Oh.
Here's the issue that I'm having,
No,
and I'm
no,
leaning
Judge.
towards allowing the instruction.
Yes.
But the issue that I'm having is that I just don't really feel like it was ever firmed up. You know, Tonelli's
He
testimony
swore-
was basically, yes, I said that I was wrong. But I don't know. I really wish this had been a pretrial hearing, to be honest.
That's not your problem,
But
Judge.
I don't feel like there was ever any testimony
Judge.
that it did, in fact, exist.
Jesus Christ.
Like to me,
There was.
Tonelli's testimony was more like, I thought we had the physical back seat, but we never did.
Now
But I don't
that's
feel
his
like it was very
testimony.
clear. And frankly, I don't really think that the defendant should be penalized when it wasn't clear. And in fact, there are at least 3 instances of Tonelli saying that there is a back seat.
Well, Judge, at the PC hearing, he said,
Judge, you got to allow
I
this.
believe the seat was located. We are waiting for a forensics analysis to make sure and confirm that. He qualified it.
Not to
and
the
that's
grand
what
jury, he
believes
didn't.
up until
Not
he
in the
got
police report, he didn't.
CSU report.
Which said,
Well, which listed the items taken from the dumpster and did not include the back seat.
and when was that?
Not until that fall.
Post grand jury
Post grand
presentation?
jury. Now, 3 years later, yes,
Yeah,
we
it's
were just sitting here and we were throwing out ideas. I mean, it was just like
You don't
I
throw
know,
out
I
ideas
know,
in
I
court, you
know.
dumb cow.
I know, but if
Bring
you're
your
the defendant
evidence.
And this detective is twice saying that there is a back seat,
Yeah.
Even though it's not listed
Judge
in
let it
discovery,
in.
and then 3 years later he mentions bringing it into court. I think it was reasonable for them to rely on thinking there was a back seat too.
Yep.
But then that was cured.
It was not cured. He was caught fucking lying. That's not
This
curing.
was subject to extensive litigation under Judge Cunningham.
Oh, it was.
Yeah.
Was there a missing evidence instruction argument?
No, but I was accused of prosecutorial misconduct.
You still should be.
I had to respond to a motion about this. It went on for quite a while.
You got to let it in,
The
Judge.
biggest problem I have is that I still don't really have any conclusive testimony about whether it ever did exist.
We have the back seat. He's
You
what
know,
he
all
told the
these
grand
CSU
jury.
people in here, why not just have someone definitively say, no, we never had a back seat?
Judge, I feel like that was conclusively testified to because the
Oh, yeah, by the guy that lied 3 times?
witness that testified.
Yeah.
And it was not found in the dumpster. Now, I thought what the court was saying was we don't know if it was ever in his car.
It was
And that is
clarified by the
something-
guy that lied about having it twice. He
Yeah,
clarified
like-
it by saying, so which do we
He was
believe?
taken out
His
3
previous
years
2
earlier.
statements
Right.
or this one?
Car with no back seat.
Right.
But every
Judge, you've got to let it in.
police witness who testified when asked said that they recovered no back seats. And the person who would have recovered, what Detective Sinelli was testifying about at the PC hearing.
The
and
person
the
who would have
dumpster
recovered it was
recovered.
who?
And Detective Peters.
Tinelli,
and
the lead.
Rebecca
She
Kimmer,
didn't
who
want to
both
finish that
testified
fucking
no
sentence.
back seat was recovered in the dumpster, although they initially thought something might be a back seat.
You got to
What
let it in,
evidence
Judge.
rule is missing
He
evidence?
testified under oath in front of the grand jury.
It's,
That's a sworn
there's a
statement.
Cooper's heading somewhere in there, Judge, about it. I understand the court's looking it up. Judge, just to respond, for what it's worth, I think this ambiguity is why it ended up as a jury.
Exactly.
I
It's
mean,
up to the
that's
jury
kind
to
of what I'm
decide.
leaning towards is
Good
like,
point.
the problem is it's been left pretty
It's-
unclear.
It's up to the jury
I
to
think that
decide
that should
whether or
lean
not they had that
towards
seat and fucking
The
lost it.
defendant, let me look at this.
It
too.
goes straight to his credibility. It goes to the judge. You can't do this.
But there was not ever a spoliation or missing evidence instruction before now, right?
No.
Okay.
So it's not Jesus. Judge, you gotta do it. Exactly, MG Law. Exactly. I need to get my air purifier back in here. I moved it in the other room the other day. Had Russian friends over for cigars last night. Forgot to bring the air purifier back in here. The jury's the one that's going to decide whether or not they had a backseat and lost it, or whether they lied, et cetera, et cetera. While she's chewing over this, screwed him a booger balls with $2 because I can. Thank you so much. And that dog in him been sick for the past few days. Will be making a hot toddy when I get home, but I'll still be here. Hey, enjoy that. Little extra alcohol in there. That'll
I'm
go a long
going
way.
to allow the instruction.
You got to do it.
I do
you
think
have to
that
allow
based on the evidence as it came out, and I'm looking at the case law in Beglin and coincidentally a case called Ordway v. Commonwealth. So it says the
That was
court
the
held
right
there is no
decision.
special or unique threshold of proof involved, so long as the trial court is satisfied that a reasonable juror could believe from the evidence the substance of the first clause, the instruction is in order. And I
We
do
all
believe
believed
that
it
the
until
way
he
that the
until he
proof
said
came
something
out,
about
a
it Friday.
reasonable juror could believe that the back seat existed at some point.
We all thought it existed until last Friday.
I'm going to allow
I don't
that
think I'm
instruction.
alone. Nice. Good, Judge. That's the correct thing to do.
All right. And then we have the unanimous verdict instruction. They are substantially similar. In fact, I think that the Commonwealth is just a little bit longer.
I don't think it, to be honest, I don't think it existed either,
Does
which is
anybody
why
have
the
any
cops shouldn't have fucking
position
told the
on whether
grand
it
jury
should
it did.
say the verdict of the jury must be in writing, must be unanimous, and must be signed by one of these foremen, or actually foreperson. Or the verdict of the jury must be unanimous in finding the defendant guilty or not guilty, and must be signed by one of you as foreperson. You may use the form provided at the end of instructions. Anybody have a position on that?
No, Judge. I mean, I'm not looking at Cooper's on it. I think whatever the
Okay.
pretty close.
All right. Then we have our verdict forms. So these will be as we discussed for the first 3 counts of the indictment will be
Hey, Yoda. What's up, Yoda?
A,
Oh,
B, or
Yoda making an
C.
appearance.
And
What's up, buddy?
then the others will just be guilty or not guilty. So our jury, oh gosh, they're already back.
Yeah.
Let me get these written up so you all can have about 5 minutes to review them, okay?
And Judge, we found some typos. Do you need us to communicate those, or do you already have those?
I don't think I already have them, but when I put this all together, we'll see if they're still there or not.
Okay.
Thanks. All right, you all can, it's going to take me about 10 minutes, so we'll take a 10-minute break. John, would you mind to let the jurors know it's going to be about another 10 minutes? Thanks.
All right. We'll mute the court here while they do their thing. Wow. I'm glad she let that instruction in. We'll talk about that in a little bit if we have some time. All right, well let's kind of do it. I like her because she starts on time. She said they were starting at 12:30 Eastern. They started at 12:30 Eastern. So good for her. Wow, let's see where we all stand here. First of all, hey, welcome to the 477 of you that are here right now. Glad to have you here. I personally am feeling much better than I had been the past few days. The voice is like right about 98, 99%. Got just get a little bit scratchy like that sometimes. But the voice is about 98% back. There's just like a little bit in the bass range that needs to come back because there's not a lot of power down in the bass range. But give it a couple days just to kind of fine tune itself, and we'll be back to completely normal. So thank you for everyone that was caring and concerning about the laryngitis. We had a relatively epic effort Friday last week. Vast portions of it were darn fun and darn entertaining. Like I said, we got the 479 of you here right now. The jury, let's see, the juries will be here in about 10 minutes. And 271 likes. So 215 of you haven't done your job. Get out there and smash that like button. You're here, you're watching them argue jury instructions on my channel. So clearly you like what you're seeing. So get out there and hit that like button. And if you haven't subscribed, I would be honored if you would do so. Hit that subscribe button. Let's see what else. Oh, we got our like and subscribe poll. We can never forget our like and subscribe poll. So hit the like, hit the subscribe, and vote. This is one of the first few times we've ever had less votes than there are likes. This one doesn't usually happen. All right, the like and subscribe and vote question for today is: has the prosecution proven guilt beyond a reasonable doubt? Has the prosecution proven guilt beyond a reasonable doubt? So far, 53% of you have said yes, and 47% of you say no. This might be the closest, I think this is the closest verdict poll we've ever had on the channel. Ordinarily, it's very heavily one way or the other. This is statistically within the plus or minus 3% percentage of error points here. One's 3% above 50, the other's 3% below 50. It's a statistical dead heat. So there you go. All right. So hit the yes or no. That's your question too. See, and this isn't how the jury, don't vote how you think the jury is going to come down. This is you personally, because the jury could I think the next poll needs to be more clear. Our next poll will be more clear because there's 3 separate charges. There's the gunning the guy down on the street, and then there's killing each of the 2 kids. I should break that up for reasons we'll discuss here in a bit. I flagged a couple of things. We've still got a few other formal things to do. Flux, Dusting, remember for 15 months, Flux was one of the original members. She's like the OG. How you feeling, Flux? Flux has been under the weather as well, too. She was unable to pronounce the word gremlins. Can you pronounce gremlins yet? Have you recovered from your flu and cold that much that you can pronounce gremlins, or is it still grublins? Dusting off an old OG meme of her. Mocha Dick Poon XOXO, fully adjustable, blow for freedom, and as always, pants are prison. Did I miss anything? Lol. I think you have to have missed something because you ran out of space before, but I can't put my finger on what it is that's missing from that. Got the Mocha Dick Poon, you got the XOXO, you got the fully adjustable, you got the blow for freedom. There's something missing, but I don't know what it is. Anyway, thank you so much, Lux. And the Japanese Yakuza 1 with the 50 sexy monies was going to make a comment about the judge, but I'd rather not. Well, thank you. Thank you for taking the high road. It's far too uncommon in these parts. It's good to see someone has a conscience. Jeff, how many years sober? Me, 0 years sober. Well, the first 35 years, well, not yeah, about that. But no, legalizes. How long is this trial supposed to last? They are supposed to have everything done by Friday. So we're thinking the defense will put on whatever case they have today. Tomorrow will be closings and jury instructions, and maybe a verdict. If not, the verdict will probably come on Wednesday. That's kind of the way I see it playing out, because it doesn't sound like they're going to put on a major defense case. But they're going to put on something, so they may go today and tomorrow. Anyway, by Friday is when it's expected to wrap up. Ecopa says he hasn't even had a week sober. That's untrue, and that's unfair, and that's mean. I have many weeks sober. I have very few weeks drunk. I would say intoxicated maybe 2, maybe 3 times, 3 days a month, but usually like 1 on F at Friday and maybe 1 other accidental night out with friends. But that's mean and that's unfair. Let's see. There's a bat in my belfry. Yes, he's not the sharpest knife in the belfry, because you have bats in your belfry because you're normal. He's not, so he gets mixed metaphors. We give mixed metaphors to people that are not altogether there. I can't see the judge with her camo top on. Yeah, the jury's not there, so well, that also answers the next question, or the next thing. Dragon Knight 57, what the hell kind of judge wears her robe flapping open with a camo t-shirt underneath? The kind where they're arguing over jury instructions without the jury present. It's much more, as you saw, it's much more informal. You know, everybody just gets to be chill and hang out, and the formal part starts when the jury comes in. So that's the chill part of the day. Did both sides rest? No, the defense hasn't put their case on yet. Don't know how long it'll be. Don't know what sort of case they're going to be putting on, but they haven't gone yet. That's what's going to happen when the jury comes back. What's in the church warden today? The church warden pipe here. That's what we've got going. It is a Champagne Carol. It's an in-house blend from Beehive Cigars in Salt Lake City, Utah. Pretty delish. Picked it up on vacation. And the Japanese Yakuza 1, I just opened the stream, and the first thing I saw was the judge, and I thought not to be mean today. Good for you. Thank you so much for 50 more sexy monies. Little dog. Oh, we just read that one. All right. And Russell Wallace, Warden, Utah's so nice. They're Elko County's hospital system. Really? I'm kind of surprised by that. Canada doesn't pay for the gold they take. Elko County, not Clark County, huh? I thought Clark County would probably serve Elko County, but fun fact, the Lorax's parents met in Elko, Nevada. Just throwing that out there. That's a fun little fact. At least I think it's fun because, hey, they made me. All right, well, that brings us up to date here. For those of you joining late again, we did lose one juror at the beginning. Apparently, the juror was hospitalized for something, but they have 3 alternates. Now they're down to 2 alternates. All right. So where do I think we come out on all this? This is actually a really, really tough decision. I mean, first guy, the guy that they just pulled up on and shot him in a mistaken identity, thinking he was a member of a gang with a hit on him. I think he's going down for murder for that one. I think he's guilty of that. I think they proved it was guilty. Everybody testified that he was the one that got out of the car and blasted the guy. He's going down for murdering the first guy. That's okay. I would vote again. The jury may be completely weird and different. So I'm not saying that's what the jury was. In my mind, he's going down for the first murder. I would convict him on the first murder, clearly. The 2 kids, though. I mean, I'll tell you right in my head, I think he did it. But putting aside what I think, what my feelings are, and looking at the evidence that was presented, I have reason to. I believe there is sufficient lack of definitiveness in the prosecution's evidence. I don't think they proved beyond a reasonable doubt. I really don't. I mean, it's reasonable to assume that Ja'Cory Taylor did this. It's reasonable to assume one of the other guys did it. It's reasonable to assume that one of the other people in the room did it. The only evidence, they don't have the defendant's fingerprints on anything important. They lied about having the back seat. I don't think the back seat was ever in police custody, but that's what you get for lying. Just going on that, the police, if you look at the evidence presented, the police had the back seat. They lost the back seat. That was the evidence that was presented to me. And I thought, gosh. See, this is a rough one. I want him to be found guilty for killing the 2 kids too. But if I was on the jury, my initial vote would be they botched this and they didn't prove, regardless of what I think, feel, and believe, they didn't prove beyond a reasonable doubt that he did it. Well, the backseat was allegedly where they kept one of the bodies in a bin while they were carting it off. They put one of the bodies in a bin in the trunk. They put another body in the back seat. So there could have been blood on it. There could have been DNA ever. See, what we don't have is any direct evidence that the defendant did this. His fingerprints weren't on anything except the steering wheel and the gear shift of his own car. Nothing on any of on the bullet casing. No, the murder weapon wasn't found. There's just a lack of direct evidence that he did this. And then we have the lies coming from the officer that got busted. He lying to the grand jury. I don't know. What do you guys think? I mean, this is rough. And this is why I blame. Okay, as I kind of mentioned this as the trial went along. Well, they don't know what the murder weapon was. They took a couple kitchen knives and a couple of hammers. They said it was a pocket knife. They said they couldn't say which knife did it. So that they don't have a definitive murder weapon. They're like, oh, one of these things could have done it, but we don't know. The tire tracks, they didn't positively match the defendant's vehicle. The footprints at the crime scene, there were the bodies where I believe it was where the bodies were didn't match the defendants. there's so many things raising doubt that somebody else did this. I mean, maybe they don't have sufficient evidence to do it, but they should have at least gone for kind of a Charles Manson argument where he didn't directly do it, but he guided it, he instructed it, he forced them to do it, whatever. There should have been something along those lines to say, well, even if he didn't do it, he was the controlling factor. And they didn't really do that. Oh, see, in Flux says I want to convict, but legally I can't. You know, this is a rough thing, but and I hate to guess what juries would do, but I can very easily see the jury going, yeah, he killed the first guy, and he probably did kill the other guy. So, yeah, there's some iffy things there. There might be some doubt in the evidence, but yeah, we're going to convict him anyway. I can easily see them doing that. I mean, to be honest, I can see them doing that probably more than I can see them taking a firm legal analysis. This is why lawyers are shitty jurors, for the people that don't want a good analysis of the evidence. But yeah, see, I'm with you, Flux. That's rough. The jury got to be unanimous for guilty. Yes, the jury has to be unanimous for guilty. It had a back seat. It was ripped out. There's pictures of the car without the back seat in it. It was clearly taken out at some point. Alice Martinez, the witness lied or what? Which witness? Which witness are you asking about them lying? If you're asking about the lead detective, yeah, he was lying his ass off on the stand. I don't know if he was lying his ass off on the stand when he was saying he previously lied. So he was either lying on the stand or he lied before, which is why you don't know which one to trust, which is why you have to throw out his entire testimony in my book. Seta says, I'm very pro-defense, but there's no way he was not involved. Now, not involved and guilty of the premeditated murder of them are different. See, that's the thing. They're maybe one of the lessers, but I think this is an all or nothing. Either he's going to go down for a first degree or he's not going to go down for anything. 1 guilty, 2 not guilty, 3 not guilty. Okay. See, and that's I think he did. I think he's guilty of all of them. But as far as just an analysis of the evidence presented, I still think there's room for doubt, a reasonable doubt about the 2 kids. So I'm with you, although it pains me to to say that. Yeah, we get to hear the other. Yeah, and the defense hasn't put on their case yet. So I mean, maybe there's something even more concrete to cast more doubt on the state's case. But I'm just saying, just from what we've seen, I don't think the state clearly met their burden of proof for the last 2 charges against the kid. Right. David had a comment up here. Where is it? Anyway, MG Law, you had a comment too. There's like 3 comments that I can't go back and find. MG Law, where's yours? Pretty much just testimony of others who were testifying to save their own hides, right? The two other people involved, they had both taken plea deals to testify, specifically to testify against him. So they had an interest in not telling the truth, and their stories didn't mesh up, particularly around the voting. Anwan, he was on the stand. He said they took a vote, and he was the only one to vote no. Then Ja'Cory, when he was on the stand, he said there was no formal vote. There was a discussion about it, and each person was asked, and everybody said no except for the defendant. So there's not a match on that story. And then we've got the lead detective doing his thing. So there was a couple of other things. All right, I'll never remember them, never find them. Well, all right, we're waiting for them to come back. If he was only found guilty for the drive-by shooting, what's the minimum sentencing? It's 25 to life, I believe. Yeah, I believe murder is 25 to life, but for him, they would be seeking the life part of it. It was originally the death penalty, but they decided that he wasn't sane enough. He was sane enough to put on trial, but he wasn't sane enough to execute. And he clearly has some mental issues. So they took the death penalty off the table, and now it's just a straight up facing life. I'm not sure if it's a mandatory life without parole in Kentucky. I have no idea. I believe it's 25 to life for murder. And Strawberry, you gotta stop that. There we go. But what do we have beyond the two dudes' testimony that Rambo directed anything? Yeah, well, that's not the. They didn't make that argument. You know, that's what I'm saying. We don't know what they could have put on if they would have argued that, but we got what we got, and that's what we got, and we ain't got nothing else. So we're just kind of killing time here, waiting for the jury to come back. It's been a little more than 10 minutes. Well, there's always a little room for reasonable doubt. Well, yeah, not always. There's some cases where there's pretty much no doubt. Most cases, in fact, there's pretty much no doubt. But I mean, the doubt has to be reasonable. We all know that. It can't be the oh, it may have been aliens too. It's reasonable to assume that aliens came down and killed the two kids. Yeah, no, that's not really a reasonable doubt. But in this case, I think there is. I think there's and by reasonable doubt, I mean essentially what you're talking about is alternative explanations that are within the realm of possibility. That's the LawRax dictionary definition. Which, I mean, it's not a legal definition, but that's kind of the gist of what it is. Is there another plausible explanation? Is there another believable explanation that can explain what happened? And for me, a reasonable explanation is, you know, Ja'Cory and/or Anwan took them out, got caught, fingered him as the perpetrator, and you know, then the cops lied about it to match the story. We've clearly got the cops lying to the grand jury. I just did. That's the alternative explanation. Ja'Cory does it. Ja'Cory himself admits to running over the guy on the street after he was shot. I'm not. He's going to go down for the first murder. I think he should. I am beyond a reasonable doubt that he committed the first murder. But as far as the other two, you got Ja'Cory, who admits to stabbing the kid 2 or 3 times after they were dead. Although the state examiner, she testified that all of the wounds were bleeding wounds. None of the stab wounds appeared to be post-mortem. So we've got him, Ja'Cory Taylor, running over the first body for whatever reason. He was there. He admits to stabbing the kids. He's faced with murder charges. He agrees to flip and testify and point his finger at someone else. Anwan, who was Ja'Cory's cousin, their cousins, he was also there. He also stabbed them. They were given he was also charged with murder. He also pled to lesser charges in exchange for a lenient sentence. And he supported his cousin's statement that this other guy did it. So you have 2 cousins, both of whom admit to stabbing the boys, flipping and getting these 10%, these 10-year deals, which only ended up being 3 years for one and 5 years for the other. That's a reasonable explanation that they did it. They're cousins. They look out for each other. They accept the deal to get this guy off the street. They point the finger at the defendant. I think that's a reasonable explanation. That's one that you got to look at. It's not one that they shut down. Now, had the prosecution done something like had the medical examiner testified that, yeah, there were a couple of wounds that appeared to be post-mortem, that would close the door a little bit. If the officer hadn't lied about the back seat, that might close the door a little bit as well. Stupid question. So if it goes to a grand jury, does that determine there's enough evidence to take it to trial? So if they hadn't lied, the case may never go to trial. Yes, that's exactly what that means. Because the defense doesn't get a say in the grand jury hearings. It's all the prosecution. The prosecutors are the only people that make arguments to the grand juries. So the prosecution goes in. That's why they say that, the old saying is a grand jury can indict a ham sandwich, because they get to say whatever they want. It has to be true. They're put under oath. So yeah, if they may, who knows what they would have done if the guy hadn't said, oh yeah, and we've got the back seat of the car too, implying that implying they had the back seat, and two, it was a substantial piece of evidence in the commission of the crime. Like, holy shit, they got the whole back seat of the car. There must be something on the back seat of the car. So yeah, that's a bad thing. You just don't lie to grand juries. I know we shouldn't have to be told that. That dog in him, that hot toddy was crap. Wish I had whiskey. Well, you gotta have whiskey, otherwise it's just honey lemon tea. That's honey lemon tea. Dang. Thank you for the super chat. That's why you should always have a bottle of emergency whiskey in the house, so you can make a hot toddy if you get sick. I'm sorry your honey lemon tea was crap. You should, if you want some good tea, you should go to the Dragon's Treasure tea, thedragonstreasure.com, to get some amazing teas. That's where I get all my teas. Just saying, thedragonstreasure.com, go there. 60 different teas every month. The loose leaf teas, he can put them in tea bags for you. Whatever you need, he's got all the tea accoutrements. TheDragonstreasure.com. Use code VICES. That gets you 10% off. So he gets a sale, you get 10% off. I get a 5% kickback, which I immediately put into buying more tea. So yeah. How was that for a cool segue? Yeah, MG Law says nothing happened to the lead investigator lying in the Murdoch case. Nothing will happen to this one either. Yeah, in the Murdoch case, we had SLED lying to the grand jury. They do this all the damn time. And as we talked about before, you can't just say, well, what's wrong with Wisconsin? What's wrong with Florida? Why? It's the only reason we see it consistently happening, and this is in Kentucky, by the way, the only reason we see it consistently happening in Wisconsin or Florida or things happening in Utah is because Wisconsin, Florida, and Utah allow cameras in the courtroom consistently. We're seeing it more. We're seeing it more there because we're allowed to see it. This is going on in every courtroom, in every county, in every state in the union. We're just now seeing it more because cameras are becoming more and more prevalent in courtrooms, which is why I keep beating my drum that courtrooms should have cameras in them. Every single courtroom should be streaming or to YouTube or some other place where anybody that wants to can go and see what's happening in any courtroom in the nation. We have the technology. It doesn't take that much to do this. Of course, there's like the child cases and things like that. There are times when you shouldn't have cameras in the courtroom, but the vast majority, from a traffic ticket to a triple murder trial, there should be cameras in the courtroom. We need to expose this. We need to shine the light on this crap, and we need to hold the prosecutors, the judges, the police officers, the detectives to higher standards. If they're going to take away your freedom, if they're going to take away your loved one's freedom, if they're going to try to, it needs to be better. No, see, this is if you that's why I'm telling people that want to know what was said to the grand jury, go back and watch the last hour and 20 minutes of Friday. The lead detective was told by another officer that they believe that they had the back seat because they found something in a dumpster. We believe we have the back seat. In the report, he put, "We have the back seat," without the qualifier. In his he admitted that in the testimony to the grand jury that he said they have the back seat with no qualifications or equivocations. They definitively stated to the grand jury, "We have the back seat." His explanation was, "Gee, I misspoke, and I really, really wish we did have the back seat, but we never did." That was his testimony to the to the grand jury and in court yesterday, last Friday. All right, we're taking a little more than 10 minutes to get going here, Judge. Get them fingers typing. Right, what do we got going on here? Oh yeah, lapel. Yeah, there's no reason why we don't. And weirdly, a lot of courts are against the idea of having wireless mics, putting like the FM microphones on. I don't know why, but they are a lot. No, don't watch it. It was brutal and dramatic, lol. Narrator, they did not, in fact, have the back seat. Yeah, it was pretty shocking. That was literally the last series of questioning from the prosecutors. Oh, there's been a lot talked about this back seat. What happened? And the defense lawyer just lit him up like a Christmas tree when it was her turn. Marv White, $5 super chat. I wake up reasonably doubting the government. You should wake up every day reasonably doubting the government. Everyone is not guilty unless it's slam dunk case. Well, I don't think it has to be a slam dunk. It just has to be beyond a reasonable explanation that something else explains what happened. Oh, and Marv White, by the way, thank you so much for the Marv White left a super thanks on one of the short videos that I released earlier. So there we go. Thank you so much for that. Anybody, if you're watching this on replay and you're like, gosh dang it, this was really exciting jury instruction arguments. I really wish I could have super chatted, but I wasn't there. Down there's a little $sign somewhere down below you there that you can click on and you can send a super thanks, which is kind of the same thing as a super chat, but we're just not live when you do it. And I'll read them and I'll mention them just like I mentioned Marv White doing that. Thank you again for that, Marv. That was very, very kind of you. And that dog in him ran out of whiskey from Thanksgiving, used Hennessy as, ooh. Trying to imagine what a Hennessy hot toddy would taste like. It doesn't sound great. The only good part is that I'm out of Hennessy. Yeah, I'm trying a Hennessy. Ugh, that doesn't sound really good. Now, like because I don't understand cognac. I'm not a connoisseur of cognac. I use cognac for cocktails. I'm trying to think. I may have some point in my life have had a couple of glasses of cognac, like just neat, but virtually every time it's been in a cocktail. It's because it can't make up its mind. Is it wine or is it whiskey? It's like it's in the borderlands somewhere between wine and whiskey, and it doesn't make up its mind. I love mulled wine. Mulled wine in the winter is absolutely fantastic. I would love to make some mulled wine, but good hell, it takes far too long. And when I want to drink, I want to drink now. Daryl Smith says Hennessy is fire. All right. It's super wine. Now, see, for me, that's like a port wine. That's a good fortified port wine. That for me, that's super wine. Yeah, see, that's again brandy. Brandy falls into the same category as cognac in my head. Again, is it wine or is it whiskey? What is it? brandy. God, I haven't had brandy for ages and ages and ages, which is, I normally, oh my God, it's coming up on Christmas and I haven't made any eggnog yet. All right, we got to do that. Eggnog. Yeah, we got to do some eggnog for Christmas stream. Brandy goes in eggnog, and that's pretty much it. But also really, really good in eggnog is Maker's Mark, because it has a little bit of a cherry flavor that really comes out in eggnog. How did this turn into a booze stream? I blame that dog in him. This became a booze stream while we're waiting. Why am I squinting? Just looking at myself there in the camera. All right, probably because it's what, 4 o'clock in the morning, and it's really dry here too. I've got the humidifier going over here, but it's still really dry. We're waiting for those of you joining, we've got the 485 of you here. We're waiting for the court to come back. They've been gone for about 20 minutes on a saying she'd come back in 10 minutes. MGL, try it with a bunch of Maker's Mark. It's pretty darn good. Or you can even use like an Evan Williams in a pinch. I'm sorry, the jury isn't back, so we drunk talk. Eggnog is eggs, like a lot of eggs, a lot of cream, a little bit of milk, some nutmeg, some cloves, some cinnamon, and a bunch of booze. In a nutshell, that's what it is. And I make a no-bake eggnog. It's just a straight kind of fermented eggnog thing. Just straight in the blender. Everything goes in the blender. It goes in the fridge and sits there for about 4 or 5 days. And then it's just amazingly delish. If you get into like the boiling eggnog, it's really, really tricky, really, really difficult, and very easy to screw up. And mine tastes more delicious anyway. Yeah, so eggnog is just basically a ton of eggs, a ton of cream, a ton of milk. Oh, a ton of sugar too. Don't forget a ton of sugar and a ton of booze. Yeah, forgot the sugar. Corn syrup. Never put corn syrup in eggnog before. Yeah, raw eggs. Raw eggs are great. They're great in eggnog. Yeah, it's like raw egg. Eggnog lattes are amazing. Nah, you don't have to tamper. You don't have to temper the eggs. No, not at all. That's a myth. Never had eggnog without. Never had eggnog without alcohol in it after I came of age. Oh no, eggnog equals drinking someone else's Hawkers if they hate Altoids. That's funny. Well, if there's no eggs, you're just essentially drinking nog. I guess it would just be cream. It would just be cream, milk, and sugar with some little nutmeg on it. What happened to a boozy coffee? Why do we got to use raw eggs? Oh, hey, go out and make an Irish coffee. Irish coffee is the bomb. Love me a good Irish coffee. Oh yeah, put some vanilla extract in, but definitely put some vanilla extract in. All right. Well, pancake batter minus the flour. Alcoholic pancake batter? Yeah, you can say that. Rum chata and root beer or orange soda. That could be good. Eggnog season is greater than pumpkin spice season. The booze will kill the salmonella season. Hey, there's a good that is by and large true, but if you're sensitive to that sort of thing, you may want to be careful. But that's the good thing about Korea. There is no salmonella in the eggs here in Korea. So bonus. Right, we are desperately running out of topics. Hurry up, Judge. Hurry up, Judge, and get back here. We've talked about the trial. We've talked about eggnog. We've talked about cognac. The dogs are here. We're just kind of chilling. The judge, the judge is not grazing Bifront. Stop it. Stop it now. Everything is better than pumpkin spice season. Well, I will say that it's gone now. I finally managed to consume all of my pumpkin spice flavored tobacco. Morbid curiosity got the better of me, and I ordered some pumpkin spice flavored tobacco for the pipe. Took me like 3.5 years to get through an ounce of it. Yep, Japan is the same. Their eggs don't contain salmonella. They eat raw eggs on rice for breakfast sometimes. I do that all the damn time. That's great. Just like a little bit of soy sauce, whip up a raw egg, drop it in there, done. And some gochujang, just if you want the spice. They eat raw eggs for breakfast sometimes. Don't know that I can get past the texture. Lol. No, it's good. The only thing that like is horrific for me as a round eye, the what is it, the natto, is that what they call it? It's like the thing Japanese eat for breakfast. It's essentially like really fermented sticky soybean clobby thing that is just terrible. It's just terrible. It's sticky and yeah, cannot do that. All right. Is it slimy? Eggnog? No, eggnog isn't slimy if you're talking about eggnog. Your husband had salmonella last weekend. Now he's terrified of chicken now. Dang, I hope you didn't cook it. I'd be terrified of you if you cooked it. I used gochujang to make Italian Calabrian pasta sauce. Worked awesome. Ooh, yum. Yeah, there we go. I thought it was the shell that has salmon. Well, let's put it this way: chickens don't have salmonella in Korea. So you're there you go. Because they don't allow infected things in. Like Korea has no rabies. There's a bunch of diseases that don't exist in Korea because they have some pretty strict quarantine requirements. What are you doing, Yoda? Silken tofu is gross for anything but smoothies. Yuck! No. The tofu is called tubu in Korea. You need to have sundubu jjigae. It's like silken tofu, really spicy soup. You need to put like beef in it, or usually they put like seafood in it. You know, little shellfish, shrimp, kind of things like that. Super spicy, super good. Who's matter? Oh, I think I want some of that for lunch tomorrow. That's what I'm gonna have that for lunch. Thank you. Yeah, the sundubu jjigae is an amazing food. Silken tofu, spicy soup. Yum. See? JKD Buck knows what's up. That's great. Australia is way more strict than Korea, but same basic principle. You're allergic to tofu? Huh. That's kind of odd. Fried tofu is fantastic. Oh, wait a minute. There we go. Fried tofu is fantastic. It's all in how it's cooked. Yeah, but you know, the fried tofu, you have to use like the really super firm, solid tofu. Otherwise it breaks down and it never really fries up. You get like really, really firm tofu. Now we've moved on to the cooking portion of the show. Well, all right. We can do this. This is a very long 10 minutes, Judge. Joe Tato says, never had tofu before. I like meat. Well, you know what? They're not mutually exclusive. You can have tofu with your meat. It's not necessarily only a meat substitute by vegetarians or vegans. But yeah, no, I said, you know, the beef tubu soup is fantastic. Yeah, it's great. they're both great. I would never use tofu as a meat substitute. There. Would eat raw fish before I eat tofu. Miso soup is fine. Well, again, there's tofu in miso soup occasionally, depending how they make it. Talk with Sally. Tofu's for soy boys. Well, so there's a country of, well, there's two countries of probably, well, if you throw in China, yeah, no. See, Sally, that's where you're wrong. You've allowed soy boys to convince you that tofu is only to be used as a substitute for meat. It's incredibly rich in protein. It's incredibly low in carbs. It's a great side dish. You put it in soups with meat. It's an absolutely amazing addition to anything. Wondering if something happened. Probably not. Probably just taking the judge longer than she thought to type it up. I always underestimate too when you know the boss or somebody says, "All right, how are you coming on that paper? How long is it going to be?" And I'll say, "It'll be about 30 minutes." It's usually like an hour and a half. I always way underestimate how long it takes me to do stuff. You can make tofu out of other beans, but then it's not tofu because tofu is literally soybeans. It's literally translates to soybean. So there you go. Paid for by Big Tofu. Yeah, I already did check to make sure it wasn't accidentally paused. I've thought of that a few times. Oh, shoot. Yeah, like, well, all right. So can we move on to Star Trek now? Scotty from Star Trek says that you should always overestimate the time needed. Yeah, you should. But, you know, I try to make it look like I'm actually faster than I am. But, yeah. Best tofu is the sprouted firm tofu from Trader Joe's. I'd say the best tofu is like the tofu that the little old lady just like right down the street from me makes and sells in the open market. That's some good tofu. Yeah, you know, it has more protein than tofu, chicken. And you know, it has even more protein and tastes amazing. Like something like mapa tubu, which is it's like a Chinese chicken tofu, spicy chicken tofu stir fry kind of thing. Yeah, so chicken and tofu makes an amazing dish as well. The Japanese Yakuza 1, thank you so much for the super chat. I do the other way around with the time. I say it takes an hour, but it takes 20 minutes. And I know, you'd think after like 30 years of doing this shit, I'd think to do that so that I look like a superhero. But I always want to make it sound like I'm almost done rather than just not almost done. How are you still awake? Who said I'm still awake? I'm awake. I slept for 6 hours before the stream. So I'm not still awake. I'm just awake. It's 4:16 a.m., 4:17 a.m. now. See, I plan these things out. Oh, we're not starting till 12:30 Eastern. That gives me 6 or 7 hours to sleep. So I did. I bought some Kraken Legal Vices pick incoming. It was on sale. Kraken rum is good. It's arguably not really rum, but it's close enough that I always consider it to be actual legally rum. They kind of usually got like dark rum, supposed to aged rum, because they add stuff to it. But anywho, yeah. Wait, Kraken squid? Oh, I thought we were talking about Kraken rum. It tells you where my brain is. Did you have to chloroform yourself, Jeff? How did you get to sleep? You lay down on the bed, you turn out the lights, and you set your alarms for 2 o'clock in the morning, and you go to sleep. The Japanese Yakuza with another sexy $50 Korean money, whatever that is. No, just kidding. I'm just surprised myself. It was way shorter than it was. What was way shorter? Oh, the 20. Yeah, all right. I should have read this one first, huh? Which I did. All right. I didn't realize it was a continuation. All right, I'm with you. Sorry. Me slow. I had a Jamaican woman cuss me out, something fierce. Brought some jerk chicken with red beans and rice from her. Went back to get some more. Nice lady. Well, what'd she cuss you out for? You should be thanking you for buying her food. It's my favorite board game. Well, that's a... Gosh, I haven't played board games in like ages. Just because there's not a lot of people that play board games here in Korea. I mean, there's a standard Monopoly. That's always great for things. If you have lots and lots of time, we do have friends that'll occasionally get together a couple times a year and play the Cthulhu-based Mountains of Madness. What is it? It's called Mansions of Madness card game. I played Magic the Gathering for the first time ever in my life, like 3 weeks ago with some friends. I can see the appeal of it. It was much different than I thought it would be. I figured after 40 years, I should jump on the bandwagon and give it a crack. Kind of like cell phones. There's that cell phone. That's just a passing fad. Jeff, like Sink the Titanic board game. Is that a real board game? Does chess count? Yeah, chess is a board game. Yeah, well, they have like a Korean version of chess called Jangi, which is really fun. I used to be decent at it back when I was a student here, and that's what we just play all day long when we weren't out doing things. But I haven't played that in years. Probably can't even remember the rules. All right, now I'm officially getting grumpy here. Come on, Court. Oh yeah, they do. It's called Paduk here. They play Go. It's called Paduk. They have like Paduk TV channels and tournaments and institutes where you go to study to play it. I do. I'm trying to find like a group of decent people because I really love to get back into D&D again. I'd like to find a decent group of people to hang with, but haven't found anyone cool enough yet. Haven't found anyone cool enough for me. I have high standards. What format did you play in Magic? I have no fucking clue. It was the first time I've ever played it. There was somebody's heads walking by. Are we coming back? I have no idea what the format we played was. I didn't know there was different formats until you just asked that question. But again, I always wrote it off as like that one game that kids play. But then when I got into it, I was, this is like the Cthulhu based game. These games where some idiot savant sat down and wrote out these ridiculous rules and figured out all this entire battle matrix and put them on the cards. I went, okay, it's the same basic essential like format. So I got it and I went, okay, this is much different than I thought it would be. Judge went to second lunch. No, there is no lunch. They started after lunch. What about a good Squid Game? There we go. Well, I would D&D with anybody here in chat. We're just kind of on opposite sides of the universe. There's a Geeks and Gamers tabletop channel. The guy Runs would have you on play. I'm sure Danny has mentioned wanting to try it too. My favorite board game is Ouija. I always win. I doubt that. I've seen movies. Oh, shoot. She's on 11sies now. I'm shit hot at trivia. Well, see, me too. That's like the thing is, I collect useless information here. Oh, sorry about it. I collect useless information in here. My brain is so full of just useless facts and things. I kick ass at trivia, but you ask me an important question about something, and I have no idea. I've got to go find out the answer because it's my brain is just full of useless shit that helps me win trivia games. Some of the Law Tube tried doing a D&D streams, didn't last long. No, Hogue started up again. They're still doing it. I think they just did it the other day. As a matter of fact, they ran some Christmas-based campaign. Trivia Pursuit is my buzz. Did you see? No, I haven't seen Godzilla -1 yet because Korea will never ever get Japanese Godzilla. They bring in Hollywood Godzilla, but they won't bring in Japanese Godzilla because Koreans hate Japanese. And Korea also has their own fake Godzilla called Yongari. So that they won't ever bring the Japanese Godzilla to the movie theaters. I have to wait until it's available for download at alternative sites. So as soon as I can get a non-cam, shaky camera in the theater recording of it, I'll watch it. So I'm really looking forward to it. I've been looking on like streaming sites and it hasn't shown up yet. Yeah, well, Korea has a good excuse to dislike the Japanese, and they don't dislike well, it depends. It's one of those things. Like they hate America, they hate Japan, but you ask them where they want to go. The first two places are America and Japan. It's that kind of thing. It's like we hate them, we dislike them, we hate them when it's politically correct to do that. Otherwise, we want to spend all of our time there, and it's a thing. Shin Godzilla was great. I loved it. Yeah. B-Flix and 123 Movies has it, but is it just like, shaky Japanese cam filmed in some semi-dark Indonesian theater, or is it a high-quality digital print? That's I'm waiting for the high-quality digital print to come out. Yeah, I've been meaning to add that to my soundboard for just ages and ages and ages. But I haven't. Dang, come on, Judge. You said 10 minutes. If you would have said more, I would have gone back and watched the trial. We got 456 people here wondering what the hell's going on. No, the court did not go to lunch. That's why they specifically started when they started, was because no lunch. All right, I got to turn off my phone messages. There we go. Who was sending me messages at 4:30 in the morning anyway? Stupid friends. All right. Did the judge get a ham hot cotton? Oh, the camera's moving. The door is open. Does that mean anything? Apparently not. Yeah. If any of you heard that those incoming message things when I was saying who the hell's messaging me at 4:30, Flux just outed herself. It was Flux. Flux was messaging me at 4:30 in the morning. Well, that's it, Kitty. That's exactly what I was just thinking. Unironically, the best way to get the judge to come back is to start doing something else. So that's what I was thinking. we'll go back and check out last Friday. We'll pick it up with the detective dude. All right. We're gonna do this. No, I do not want to watch that. Law and Crime with their new fancy new logo. They're avoiding the cut cage. They probably did it because they wanted to avoid the cut cage. That's the only reasonable explanation for wanting to change your logo. They're tired of the cut cage. Live video. Last Friday. Where are we? Day 3. Day 4. Right. We're going back to Friday, folks. And it was about an hour from the end. 3:44. Just 2 hours, and we'll go to the 2:30 mark. All right. Let's do this. I'll keep an eye on this. We will drop. Let me separate these windows so I can see what's happening in the court. All right. We will drop this screen out. We'll take off Kitty's announcement, and we will go back to last Friday. All right. This is the lead detective overacting on the stand. We'll see how much of his testimony we get to. But before we do that, we need to mention that the Japanese Yakuza 1 is me just drunk. Thank you so much for that. Jeff, order a pizza. Why aren't there 24-hour pizza joints? There's one place I know of in Seoul in Itaewon, actually right at the bottom of Hooker Hill. Every time I go there, that's like Andrew and I. We whenever he visits here, Andrew Esquire from Legal Mindset. We always hit the bars. Then when the bars close, we go and we have like street pizza and we call it a night. All right, let's go here. We need some volume.
Learn from, did you say Sergeant Lieutenant Kessinger?
Lieutenant Kessinger.
Lieutenant Kessinger, that
And
Peters has identified the dumpster where he thinks there's a backseat.
Yes, ma'am.
Did you know, was Peters talking about an intact backseat like you would extract?
so this is the backseat argument. Gotta bump back a little bit. Oh wait, we're far too close to the end. We need to get like way back here. Is that where we want to be? Yeah.
Yes, ma'am.
And we heard from the lab analysts that they're sending you reports in 2017. Is that approximately when you received those reports?
Yes.
And during all of this is your only case.
No.
What
No.
else are you doing?
Oh my gosh.
Oh my gosh.
2016 Louisville homicide. We broke records on homicides. We had over 100.
Chewing on a bone right
homicides.
behind me.
One of the highest epidemics of the heroin epidemic. Homicide is in charge of not just homicides, but also death investigations, suicides, overdoses. No, this was not my only case. In fact, I think in November of that year, I was also the lead detective on the double homicide with 9 people shot during Thanksgiving.
He's a busy man. And again, I mentioned this yesterday, and people say, "No, you prefer man spreading." No, I don't. To me, it's disrespectful to cross your legs in the courtroom on the stand like that. This is a formal proceeding. Somebody's life literally is hanging in the balance, and you're just chilled there like you're watching sports on TV, looking cool in your weird waistcoat thing. I just think it's disrespectful to cross your legs in court. In fact, maybe it's just like here in Korea, because Korean judges will light you up if you cross your legs. I mean, they will call you out and likely boot you from the courtroom. Full stop. It's a respectful place with respectful proceedings, and you should be treating it respectfully. I hear it in Korea. I've seen people thrown out of court for crossing their legs, for like having their top button unbuttoned, the tie kind of hanging loose. They're pretty strict here on decorum.
I have a question. I want to ask you a question about the lab testing we heard earlier. We were all using a lot of numbers. Sorry, that we have reports that you have for the case. Was this the leather strap we've seen in the photo that's on Larry's arm at the time of his death?
Yes, ma'am.
And were these the knives that Detective Middleton collected from the house?
We're gonna have to get through this like talking from a mile away stuff.
We're up.
All right, this is the backseat argument.
It easier for the lab and for the processing is to get as much information as we possibly can, which includes getting anybody that could possibly be inside that vehicle at any given time.
And were those acquaintances of Christopher Jensen?
Yes, ma'am.
Now, we've heard a lot in this trial of questions about the backseat of the car.
Yes, we have.
Can you tell the jury what you know about the backseat and when you knew things about the backseat?
Okay. I know the back seat was cut out of the car. That we know. I know that I was informed when Detective Peters got to the dumpster and he told Lieutenant Kessinger that they found it. I understood that they found it.
Guy 1 tells Guy 2 they found it. Guy 3 overhears Guy 2 talking about it and assumes they found it, but Guy 3 happens to be the lead detective on the case. The guy who's supposed to be in charge of everything and know exactly what they have and don't have. So Guy 3 gets, double hearsay without checking
I know
it.
now that we do not have the back seat. We never had the back seat. And it wasn't until months later when Anwan Carter gave the distinct and clear testimony,
With interview?
interview of where a possible location of the backseat could be.
So after they have the back seat, allegedly, then they don't have the back seat, and then they have one of the accused guys testify that they just randomly dropped off the back seat in some random guy's garage so that they could never find it again. That's a pretty convenient answer for me, but yeah, so that's his deal. He found out months later, and you know what he never did? He never went back and he never corrected anything when he found out they didn't have it. He never went back and said, "Oh shit, sorry, we never had this. We need to," as I said, file an amendment. We didn't bring in for any additional questioning to ask about this. We didn't do anything to show that we had made a mistake and we're now correcting that mistake. Nothing was done in that regard.
I went into depth with Anwan Carter on several levels to try and figure out where that back seat was. And I could not locate it in any way, shape, or form. I tried desperately.
Did he tell you a neighborhood?
He told me a neighborhood, but as I'm sure you're well aware of, you can't go to a judge and get a search warrant for a geographical area without some.
You can't go to a judge and get a search warrant for a geographical search for a geographical area without some specific information, but apparently you can very easily lie to the grand jury about having something you couldn't get a search warrant for a general geographic location about.
Specifics.
So until Carter's
Darmok and Jalad at Tanagra, arms open wide.
interview on October 16th, did you have
Sorry for that weird
any
Star Trek reference.
direction to take about where to locate this backseat?
No.
And until you got Kimmer's report on the dumpster on September 7th, did you even realize that CSU didn't have the backseat?
No.
Thank you. I have no further questions.
Does anybody need a break before we begin?
And the walls fell. You're a nerd too. Okay, no, that was their big explanation. That's what they thought that was going to explain everything away. We thought we had it, but we didn't. Sorry, my bad. They thought that's when they said no further questions. They rested their case. They thought, okay, we've sufficiently explained away the backseat. We don't need to talk about that anymore. End of testimony, end of case. We'll turn it over to the defense now. Yeah, she did the defense, she did not let it go. So she's gonna light him up here in a minute. I hate that episode so much. The language makes no sense. That's because it was all metaphors. They were speaking in metaphors. But it is a ridiculous episode. Judge is still not back yet.
Detective, you were lead on the case of Larry and Maurice, correct?
Yes, ma'am.
And not involved in the investigation of the Christopher Jones shooting, correct?
No, I was not.
So only what we've been referring to as the May 22nd incident, we'll say, is what you were lead on, correct?
Yes, ma'am.
Now, as lead, that means that you oversee the case, correct?
Yes, ma'am.
You, as lead, are responsible for the investigation, correct?
Yes, ma'am.
You, part of that includes supervising the roles and duties of other officers
Yes, ma'am.
and overseeing the collection of evidence.
Yes, ma'am.
Dude, chill out with that bones, Robs.
So you were responsible for the evidence that was sent to the lab for testing in this case?
Like, and what form? I'm sorry.
Responsible in, I guess, as lead, deciding what to send to the lab.
There were several discussions on a round table as far as what we should send and what we shouldn't send. As a lead detective, you have to rely on the people that are around you and the CSU techs, because honestly, that's not my profession.
But you would agree that you're the case officer listed on the laboratory forms?
Yes, ma'am.
Yeah, you have to rely on everybody, but also as the lead, you take responsibility for everybody and everything that everybody does. And you better goddamn well be sure you've got the largest piece of evidence in the trial actually in your possession.
And so you requested several examinations of evidence in this case then, it sounds like,
Yes, ma'am.
including the shoe and tire print identification.
Yes, ma'am.
And so you asked the lab as part of that to compare the tire tracks and the shoe prints that were found at the scene of where Larry and Maurice were located, to compare those to Mr. Rhodes' suspected vehicles, correct?
Yes, ma'am.
And his suspected shoes.
Yes, ma'am.
And you could not identify Brice's vehicle as making those tire tracks.
I believe, and I could be wrong.
You are wrong. Now listen to him obfuscate here. Listen, the question was very, very simple. Listen to him squirm to do anything in his power to not say that they didn't match.
Brice's vehicle as making those tire tracks.
I believe, and I could be wrong, ma'am, but I don't think they included or excluded it.
I just want to know, did you get a positive identification on those tracks belonging to either of Brice Rhodes' vehicles that have come up?
I don't believe we got a positive or a negative, ma'am. I think that how they stated it they could not be included or excluded.
But the question is, you didn't get a positive to match.
No.
Okay. And Brice's,
he does this repeatedly. He hears the question, he takes some sort of middle ground repeatedly until he's forced to admit, yeah, we didn't really have that. Sorry.
Shoes were not a match to the footprints.
No, ma'am.
You showed the jury, I'm sorry, you didn't personally, one of your colleagues, I believe, showed the jury a picture of the blue Mazda in this case, in which luminol had been sprayed.
Yes,
And
ma'am.
Do you recall seeing that
No, I
photograph?
was not here that day.
Okay. Have you seen that picture before, though, at
Yes,
some
ma'am.
point in the investigation? And there was some blue lit up in that vehicle that I guess law enforcement believed to be blood.
We interpret it as such, yes.
But when it was sent to the lab, it was not in fact blood, correct?
I don't think every part was. I would have to refer to I mean, we just had the testimony,
Right.
and I don't want to say differently than what the testimony said. A specific part? Can you give me a specific?
I can flip back, but what I'm referring to is the picture that the jury saw. It had a bunch of blue on it,
Mhm.
but that wasn't blood when the results came back.
I don't believe so, no, ma'am.
Yeah, there's your answer. Nope.
You also requested the lab perform DNA analysis on the evidence, correct?
Yes, ma'am.
Okay. And you tested under Larry Ordway's fingernails for DNA foreign to him. You tested the carpet, the blanket, other items. None of that had Brice's DNA on it, correct?
No, ma'am. It did not.
And in fact, the only piece of evidence that had Brice Rhodes's DNA on it was his steering wheel and the gear shift of his own vehicle, correct?
Correct.
The leather strap that was spoken about to restrain Larry Ordway,
Yes, ma'am.
that did not have Brice Rhodes's DNA on it, did it?
No, I do not believe so. I don't believe it had anybody's. I don't think they could pinpoint because it was too small of a sample.
Yes.
All right, they do a little approaching the bench. Now, rumor has it he's had a serious staph infection in the back of his head for quite some time.
Detective, you testified that Ann Juan Carter was interviewed by you.
The
Correct.
first time, yes, ma'am.
And isn't it true that Mr. Carter did not involve Brice in the death of Larry and Maurice until after you told Mr. Carter in that interview room that Brice was throwing him under the bus?
See, that is important information there. When Ann Juan was talking about the murder, when he was giving his interview, he never pointed the finger at the defendant until, as the defense lawyer just said here, until the detective lied, which they're allowed to do. The police are allowed to lie to you during your interrogations to try to trip you up, to try to confuse you, to try to make you think things are happening when they're not. The police have the ability to lie to you. They're allowed to lie to you in the interrogation, but that's when shit like this happens. They're not pointing the finger at Brice. Ann Juan didn't point his finger at Brice. He didn't say Brice did this until this detective told Ann Juan that, hey, he's over in the other room. He's spilling the beans and he's saying you did it, which was a lie because Brice wasn't doing that. So he lies to Ann Juan and says, hey, Brice is throwing you under the bus saying you're the one that did this. It's a lie, which they can do. And so Ann Juan says, oh, well, let me tell you what Brice did. So so does that mean that he was protecting Brice until Brice started to throw him under the bus? Or was he saying, oh, that mother effer's pointing the finger at me? Well, I'm going to point it right back at him. This is why I don't think the police should be allowed to lie to you. It calls into question the credibility of the entire statement process. I hate the fact that police can lie to you during the investigations. Because it's far too easy, and I'm not saying this is what happened here, we just don't know. It's far too easy for them to do, oh yeah, he's over in the other room, throwing you under the bus. Oh yeah, well, that's that's a lie. I had nothing to do with it. So I'm going to throw him down. I'm going to throw him under the bus. And then he says, yeah, that's my statement. And then he comes to trial and he doesn't want to testify about that particular statement because it may or may not have been true at that time.
And blaming him for all the murders. Throwing him after you told Mr. Carter in that interview room that Brice was throwing him under the bus. And blaming him for all the murders.
I would have to refer to the interview. If you have it, I'll be happy to refer to it. If you could show me the page and information, that'd be great.
And this is a long transcript, detective, that I've turned to the page of where I believe that.
Oh, never forget that, Daily Quick Bites. Never forget
Can I-
that.
Sure.
Thank you
Feel
so
free
much.
to look.
I appreciate it. Thank you.
And that's where he goes after he's like, oh yeah, he didn't really
Are you sure
mention
this
that.
was me and not Sergeant Lesser, man?
This was from the first interview on.
Are you
May the
sure that's
26th.
me? The fact that the defense lawyer is more sure it's you than you're sure it's you should tell you something as well. He's no longer a police officer, by the way. He does something else. I can't remember what it is he does. But yeah, and of course he goes back to this default explanation that once he goes, oh yeah, oh my God, he never did mention Brice until I said Brice is throwing him under the bus. Then he mentioned Brice. Huh. Well, it's an investigative technique.
But during the second part,
Right. I believe that was Sergeant Lesher.
you were present
No, ma'am, I was observing.
from another room?
Yes, ma'am. I don't believe this was me. I believe that was Sergeant Lesher. I could be mistaken because their names are not on there. Our transcripts have names.
I understand. But you will acknowledge that that was said to Mr. Rhodes, or excuse me, to Mr. Carter.
As an investigative tactic, absolutely.
Thank you.
Can you remind me what it was? I'm sorry.
Judge, my question was that to Detective Tonelli, that isn't it true that Mr. Carter did not mention Brice Rhodes being involved in the murders of Larry and Maurice until after one of the detectives told Mr. Carter that Brice had been throwing him under the bus?
Thank you.
But we just watched Mr. Rhodes' interview, and you did interview Mr. Rhodes.
Yes.
And that was not true, was it?
I'm sorry, what?
That Brice had thrown Anwan Carter under the bus?
We use investigative tactics to gather the truth, ma'am.
Ma'am, but sir, but I'm asking
Ma'am.
you if it is.
See, that's the thing. What was it true? Did you lie to the suspect? Did you lie to the suspect was the question. He said, well, that's an investigative technique. So yeah, well, we weren't asking if it was an investigative technique. We're asking if you lied to the guy. Again, they can do that, but they shouldn't.
Truth, ma'am.
Ma'am, but.
Ma'am.
We use investigative tactics to gather the truth, ma'am.
Ma'am, but sir, but I'm asking you if it is true that when you told Mr. Carter that, had Brice Rhodes actually thrown him under the bus? Was that true? A true statement to Mr. Carter?
But ma'am, I was not the one that conducted the interview.
Detective Tonelli,
You
it is
conducted
a
the
yes or no.
interview
Was
with-
it true or not?
But I wasn't the one that stated.
You
that.
know if it was true or not, don't you?
Oh, yes, yeah, I'm
Okay,
sorry.
please
I'm sorry.
answer.
I was confused about, I apologize. Yes. No, it was not true.
He's arguing with the judge. He's arguing with the lawyer, and then finally the judge is like, "You can tell us whether it was true or not." Oh yeah, I'm sorry, I misunderstood. After he can no longer avoid it, he has to admit that he lied, which they can do.
And Brice hadn't actually said anything about N1 Carter at that point.
No, ma'am.
They are back, folks. Let's take this down, put them back up. Wait, shut up. There we go. Where are we at? Here we are. Boop. Right. They're mulling about the courtroom.
None of the murder or manslaughter. Well, no.
Hang on 1 second.
I don't know if they're
Okay.
going to put on a
The
case. This is
murder
weird.
Charges do not have complicity, although the manslaughter charges do.
So we're doing intentionally, wantonly, complicity, and official proceeding, right?
Yes.
Okay. Got it.
So then, Judge, on page, for instance, 4 on the murder 1A, it does not have complicity in it.
Okay.
So that needs to be added. It is in 1B, and then that pattern follows for each of the murder charges. Complicity needs to be added to each of them.
Okay. So on 1B, 2B, and 3B.
1A, 2A, and 3A. It's in all of the manslaughter charges, but not in the murder charges.
Murder should be 1A, 2A, and 3A.
I'm sorry. The complicity language is not in the murder charges.
And it should be?
Yes.
And it
It's
should not, and it should also be in manslaughter?
correct.
Okay. And that should be in 1A, 2A, and 3A.
Yes, ma'am.
Hang on, let me get that in.
Yes. Yeah. So all that time and she still didn't get it right. Yeah, there's not much time left.
Okay.
So is
I
it
don't
in,
know.
like, for instance, he acting alone or in complicity with others killed Christopher Jones by shooting him with a firearm?
No, it is. He killed Christopher Jones by himself or in complicity with others by shooting him with a, or by stabbing. Okay.
No objection. I noticed in 1B, it says he killed Christopher Jones by himself or in complicity with others, and then it should say by shooting him with a firearm.
Yes, I changed all of those.
Okay. And then so for 2A murder and 3A murder, the same change with the complicity.
Yes, I've changed all of them.
The only other thing I noticed was that in the verdict forms, A, it says we the jury find the defendant not guilty or murder instead of murder.
Adara the Wholesome got a feeling like this will be Ohio v. Mitchell. Cop shot a hooker in his car. It all looks bad now, but we'll see. We'll see after the defense. 1 hour behind stream, though.
That's all notice about the law.
We had a few other-
Nobody messaged she should just skip
I'm
the
gonna
next
change
hour.
that order of and the other ones as well.
That was a good trial, Ohio v. Mitchell. The cop and the hooker in the car. Bridget, I don't know how to answer that question. Jeff, do you think the defense even needs to
Okay.
present a case?
Your Honor, on page 1.
It's a
under
gamble
the
to do it. It's a gamble not to do
the
it.
Change foreman to foreperson.
Yes, thank you.
Would
And
they
I'm not sure
call?
if that's
I don't
the
know.
only location of that word, but I can
I'll
pull it up.
double check it.
The defendant? I mean, he's
And
doomed if he
then
gets
I
on the
believe
stand.
only other correction is a lettering. On page 6, for example, on 2A, we have 2 Bs. I think it's.
Oh, boo. I told you not to tell her anything. It's just let her sit through
It
it.
says B. for
I
the-
know I didn't
it
say
says
that,
A
but-
For the first option, it says B, and then it says B again.
Oh, I see it.
And then.
I changed my mind. We should have just let her watch the,
page 8 for
the horrible
instruction
hour we
3A.
just sat through.
Hang on just one second. Let me get that formatting correct. Okay.
On page 8, under 3A, on instruction 3A, we have a C and a B, which should be changed to an A and a B.
Got it.
And then I believe page.
Oh, missed
12,
it. Yeah, the who you gonna call? Ghostbusters.
we have,
Good one. Should have thought of that. I wish I would have thought of that myself.
And D, the last one should be a C.
Page 12, you said?
Page 12, yes.
No, that goes under B.
Okay.
That's the, because it's not a separate element.
Now we sorted that out on day 2, King Ginger.
That's just the intentional portion. So it should be the same for 2A and 3A.
Wow, the gap is closing on our like and subscribe poll. Has the prosecution proven guilt beyond a reasonable doubt?
And then I believe
Yes
there's
is down to
some
51% and no is up to 49%. Again, well within the statistical margin of error. We are almost 50-50.
17 and 18.
A instead of,
Be on our list.
Never has there been this close of a guilty or innocent poll. This is the closest we've ever been. 51 to 49.
I see. Because it went to CD. I gotcha.
We can play tic-tac-toe on the defense lawyer's jacket if we get bored. Meanwhile, bailiff is protecting everybody by texting on his phone. Now's your chance. Now's your chance, Rhodes. He's looking at his phone. Masked up lady there next to him. Going full ninja in court.
Okay. Anything else?
We're 5 years on
Judge, we did do what you asked, and we discussed
from COVID. We're almost entering our 5th year of.
versus tomorrow. I think that we concluded that it will not slow us down to do closings first thing tomorrow, as long as both sides
They're
are
not-
ready to go straight into penalty.
They're not going to put on a case.
And we can. We've already done penalty
I
instructions.
just hate to send them home, having been sitting here since 12:30.
Yeah, let's get some jury in here. Nice horse. She's gone full horse now.
So we have to do instructions. And then you all think you'll be about an hour each? Is that right?
Yeah, probably less.
Okay, so apparently the
think I'm
defense
just
is
gonna
not
push
going to put
through.
on a case. They'll do 1 hour each. Closing arguments, and then that's it. Dang.
Janelle has left, so it's me making the copies. Please bear with me.
Wow. In court copy machine. When she said they're going to plow through, I'm not sure what she was referring to. Experts on to testify about what exactly, Giselle? You gotta have something for them to testify about. What are you talking about, Judge? We can't hear you. Something about the jury waiting and having rides or something. Just talking about third lunch. All right, Judge, we're waiting for you to say something important. Inform us what's happening here. Okay, someone needs to be told to knock that laughter off in court. That's ridiculously inappropriate. To be laughing that loudly when there's hearings going on. Literally nothing's that funny anyway, let alone in a court where there's hearings going on in not just this courtroom, but others. It's the jury when he found out he was putting on a defense. Ouch. Yeah. Bridget says, well, this is a boring day in court. Zzz. Yeah, jury instruction day is always a boring day in court.
The copies are still running. While they are, I'm going to bring the jury in, check with them to see if there's any issues with the admonition, tell them what's going on with Tonelli being gone, let you all rest, approach, we'll do DV arguments again.
Tonelli being gone?
Should be done. You ready?
Why do we care what Detective Tonelli's doing? What's the issue with Tonelli being gone? Why does he even need to be there? He's the detective. He's done testifying. He doesn't need to be there. I'm curious as to what she means by the issue with Tonelli being gone. Tonelli's the Olive Garden detective we were just watching. Yes, Dax was the what the hell was the race of people? Not trilobites. What the hell were they? I know they weren't trilobites. Tribbles, no. What was her race of people called? Dax. It started with a T, didn't it? Curzon Dax was her name. What was the Trills? That's right. I knew it started with a T. They were Trills. Yeah, I definitely knew they weren't trilobites. But yes, they were Trills. I knew it started with a T and an R.
We talked about it already.
I knew this was a different one.
Somebody needs to polish their shoes. Oh, it's the defense lawyer, because you can see he still has his fucking pant leg tucked into his sock, and he hasn't felt that for the last 3 hours.
Well,
Did she say well or oh hell? What? I wonder if he's gonna like rewatch this and go, "Oh God, I had my pant tucked into my sock the entire day." How do you not feel that? By the way, you can't, like, if my pant leg gets stuck in a shoe or. Okay, and more importantly, what kind of monster puts their socks on after they put their pants on? Okay, so there's one man. There's, I assume two. There's a fat dude. Oh, there's twins. Looks to be mostly male. There's another, I hope female. Female, 3, 4. Looks another fat dude who's walking on the back of his pants. Okay, it looks like it's about half and half. Oh, there's a guy like, hey, don't forget me. I thought those were Doc Martens. He's not wearing Doc Martens. Oh, it's the sheriff.
thank you. All right, good afternoon. Let me apologize. You know,
Okay,
we
let's
try
get some
so hard
answers.
to make things go as scheduled, and sometimes it just doesn't happen. I can't tell you how much I hate it when you all are sitting there for that long. But I assure you we were doing the best that we could. Is there anything that anybody needs to report with regards to the admonition? Did everybody get their phones over here?
She forgot to zip
Okay.
up her
We have
robe.
one juror missing, as you can see. What we understand is he's fine. I don't want you all to be worried about him, but we have gone ahead and excused him for health reasons. Also, Detective Tonelli, you'll see, is not here. With his permission, he has asked that I convey to you that he had to go out of state. His mother was having surgery, and we told him, you know, go ahead and go. We are going to move into the next phase of the trial. When we left Friday, the state had rested their case. Would the defense like to call any witnesses?
Your Honor, the defense rests.
All right. Would you all approach, please?
All right. No case officially no case by the defense, which they don't have to do. The defense does not have to put on a case. They don't have to say word one, which is exactly what's happened here. So their closing argument is just going to be centered around the fact that their alleged fact that the prosecution did not prove their case beyond a reasonable doubt. And I hope to God that checkerboard lawyer there, the woman, I hope she gives the closing arguments. That's his only chance of at least being found not guilty for 2 of the murders. If he's definitely going to go down for the first guy. I can't see any way he wouldn't go down for the first guy.
In just a moment, you can have a seat.
But if she does it, at least there's a prayer he may only get one. If Colonel Sanders does it, he's probably going to go down for all three. He's probably going to go down for, I don't know. I hate trying to guess what juries are going to do. We just don't know. All right. Oh, dude. Not only is your pants tucked into your sock, you are wearing a red shirt with a red tie. Who does that? I am fashion void, but even I know you don't wear a red shirt with a red tie.
Deputy Mills, there should be 14 copies of instructions.
Adara the Wholesome, the $2 super chat, changing my stance. He's doomed. Also, socks before pants. Underwear, socks, shirt, pants. That's the order. Anything else is monstrous.
Now, ladies and gentlemen, I am going to instruct you on the law of the case. That's what you're getting a copy of, is your instructions as jurors. After I have instructed you, and that is a thing that I must do, is read through these all the way for all of you. After I have read the instructions, the attorneys will give closing arguments. Closing arguments, just like I told you in opening statements, are not evidence, but they are the lawyer's chance to talk to you about
I might not be
how
able to
they
finish
sum
this.
up
I
the
might have to go to
evidence
work.
and recommend how you should find after closing arguments. Now, after closings, you will retire to the jury room, where the first thing you're going to do is select a foreperson. That person will preside over your deliberations. It doesn't matter really who it is, as long as you all agree that that person will be the foreperson. The foreperson's copy of your instructions, it really doesn't matter, but you need to have like one official copy. So generally the foreperson's copy will be the copy that you sign. There's no reason for the foreperson to sign any more than one copy, and that will be the copy that you return to the court. If you go back for deliberations and you have a question, please write it out and then knock on the door. There will be a deputy stationed outside the door of the deliberation room at all times. So if you have a question, you are allowed to ask questions. You would write it out, knock on the door or open the door, let the deputy know you have a question, and hand the deputy the paper. And then we will discuss it in here, and I may or may not answer your question. The same thing for when you reach a verdict. Just let the sheriff stationed outside your door know that you have reached a verdict, and we will bring you back in as soon as possible. Now, during deliberations, you can only talk to each other. The deputy will keep your phones. I'll give you a break before that if you need to call anybody and let them know that you might be here a while. If during your deliberations you need to use your
she
phone
wants a
or you
verdict
have some kind of
today.
emergency, please advise the sheriff. They, as I said, will be posted outside the door at all times. They will come and tell me and see if it is okay for you to use your phone. There are restrooms also in the area where the deliberation room is, so you don't need to leave for that purpose. All right, at this point, I'm going to read the instructions to the jury. In the case of 16 CR 1891, versus Brice Rhodes, these are the jury instructions. Presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant, Brice Rhodes, not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as foreperson. You should use the form provided at the end of these instructions in writing your verdict. Right to remain silent. A defendant is not compelled to testify, and the fact that the defendant, Brice Rhodes, did not testify in this case cannot be used as an inference of guilt and should not prejudice him in any way. Tainted evidence. If you believe from the
Tainted
evidence that
evidence.
there existed certain items that were
Run
potential
away,
evidence
I've got to.
and that the agents or employees of the Commonwealth unintentionally tampered with them, you may but are not required to weigh this evidence in favor of the defense. Definitions. Intentionally. A person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or engage in that conduct.
Yes, the defense rested without doing anything.
Wantonly. A person acts wantonly with respect to a result or to a circumstance when he is aware and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the same situation. Complicity means that a person is guilty of an offense committed by another person when, with the intention of promoting or facilitating the commission of the offense, he solicits, commands, or engages in a conspiracy with such other person to commit the offense, or aids, counsels, or attempts to aid such person in planning or committing the act. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Instruction number 1A, murder as to Christopher Jones. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. And B, that in so doing he caused the death of Christopher Jones intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Christopher Jones under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form number 1A. The verdict forms correspond with the instruction numbers. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction number 1B. If you found Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, let's proceed to instruction 2A. Instruction 1B, second-degree manslaughter as to Christopher Jones. If you do not find the defendant, Brice Rhodes, guilty under instruction number 1A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. And B, that in so doing, he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using verdict form 1B, then move on to instruction 2A. Instruction 2A, murder as to Maurice Gordon. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife. And B, that in so doing he caused the death of Maurice Gordon intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Maurice Gordon under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 2A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 2B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 3A. Instruction 2B, second-degree manslaughter as to Maurice Gordon. If you do not find the defendant Brice Rhodes guilty under either instruction number 2A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using Form 2B, then move on to Instruction 3A. Instruction number 3A, murder as to Larry Ordway. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing, he caused the death of Larry Ordway intentionally, or that in so doing, he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Larry Ordway under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 3A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 3B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 4. Instruction 3B, second-degree manslaughter as to Larry Ordway. If you do not find the defendant Brice Rhodes guilty under instruction 2A, that should be 3A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing, he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using Form 3B, then move on to Instruction 4. Instruction 4, tampering with physical evidence. You will find the defendant Brice Rhodes guilty of tampering with physical evidence under this instruction if, and only if, you believe from the evidence beyond a reasonable doubt all of the following. A, that in Jefferson County on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, destroyed, mutilated, concealed, removed, or altered items from 763 North Height, including a pink blanket, the knife, and or the backseat of the blue Mazda, and that in so doing, he believes that an official proceeding may be pending or instituted against him, and he did so with the intent to impair the availability of the evidence at such a proceeding. Please indicate your verdict using Form 4, then move on to Instruction 5. Instruction 5, abuse of a corpse, Maurice Gordon. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Jefferson County on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Maurice Gordon in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in so doing, he intentionally treated Maurice Gordon's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using verdict form 5, then move on to instruction 6. Instruction 6, abuse of a corpse, Larry Ordway. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. You'll see there's a typo where the word following is written twice on this one and the one before. That in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Larry Ordway in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in doing so, he intentionally treated Larry Ordway's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using form 6. This is followed then, ladies and gentlemen, by a single verdict form for each instruction that I have just read to you. You will need to follow those instructions, and as I said, have the foreperson sign as appropriate in line with your verdicts. Now, we are going to have closing arguments. I expect that they will last until about 5:15 or so, maybe 5:30. Would anyone like to take 5 minutes to step outside and make any calls or anything that you might need to make? Because once we're done with that, you'll go straight into deliberation.
Wow.
That's up to you all.
Oh, that's an inappropriate way.
It just depends, on how it goes. So does anybody need to step out? All right, let's take 5 minutes. I'll have you come back at 3:35. Please remember the admonition still.
Wow. I didn't like the way she answered that. I thought that was a bad way to answer that question. Are we going to be here late? It's up to you. See, that could be like, oh, I got something to do. Let's get out of here quickly. I mean, it's not anything that's going to be reversible or anything like that. I just didn't like the way she worded that. She should have said, well, we'll deliberate as long as possible. If need be, we'll deliberate as long as possible, and then we can come back tomorrow. Or, I mean, something to that effect. Not, well, it's up to you how late you stay here. Well, now we're back to another break.
Am I okay? No. But I'm going to keep going until I am.
Why is the judge not okay? Cold? Sickness?
Just overwhelmed.
Well, we'll have to see how it goes. All right. So what's all your take on all of this? Hearing the jury instructions, hearing that the defense is not going to put on a case. What do y'all think? We got what? Let me know here in chat what you guys are all thinking. Right. Let's see. E. Copa says he's boned. All right. I don't know what to think. What's happening to Harper? Guilty. We got a guilty. Well, I mean, there's guilty of what? He's been charged with a bunch of stuff. Guilty of the first murder, guilty of all three of the murders. Lots of guilties. Prosecution evidence is weak. Yes, guilty on all. Hell, I was planning on getting a couple more hours sleep before work. Guess not. Hmm. Oh, Senator Chris, thank you so much for the super chat. He's sunk on the first guy, the rest not sure. Justin says the state did not prove their case. Did the prosecution put Rhodes at the scene of the crime? Well, the scene of the crime was his living room. Yeah, he was there. It happened in his living room. Their argument, the defense argument is it was other people in the house. Yeah, so the scene of the crime was his living room. The desecration of the bodies, no. They did not conclusively put him there, other than through the statements of the witnesses who took a plea deal in order to testify in exchange for testifying against the defendant. So yeah, the crime scene happened. It was his living room. So yeah, that's there. All three. Well, then he's guilty, says Bush. State did not prove their case for the second and third murders. Another case of the cops not helping themselves. Incompetence rules the day. Guilty on all counts. I mean, I'm not satisfied, but I think he'll be convicted. See, that's the thing. I never predict what a jury will do. It's impossible to predict what those juries will do. It's kind of yourself. If you were on the jury, how would you decide the case if you were on the jury? Guilty murder on one. I'm 50-50 on the boy. Yeah, you can be 50-50 now. Well, okay, you can be 50-50 until the closing arguments are finished. Then you have to make a choice. Seta said, to be fair, the witnesses didn't put him at the scene of the desecration of the bodies either. They were cleaning up at his home. Yeah. You are correct. One minute remaining until we're not back in court. The others that took a plea deal are questionable, but it's too hard to determine if they were sus or scared. Well, looks like are they opening it up for the jury? No, one of the lawyers is leaving. Guilty, period. I'm going to say not guilty. Interesting. Still think he's guilty on all, just pointing out that they didn't actually have anything on that one. Well, then, if they don't have anything on that one, then you kind of have to vote not guilty, I think. I mean, I see what you're saying. You think he's guilty, but they didn't prove it. Yeah, that I can get behind that. Rhodes is kind of like a cult leader. See, that's why I'm saying I'm surprised the prosecution didn't go more towards that Charles Manson kind of thing, where he was pushing them to do it, he was leading them to do it. At least as an alternative argument. That carpet is like 1980. All right. How about people start walking the other direction? No, come on, people, start walking in. I think the judge is with child. We do have a few things here. Let's see. I think we've read all the super chats. We did not read the Japanese Yakuza. Why do I hear Jabba the Hutt's voice every time the judge talks? Sorry, I didn't want to do it, but I just had to. I tried to be a little more this year, but there she blows. You're a bad person. You're a monster. Shame on you. Why is everybody walking out? How about walking in? Start walking into the courtroom. There we go. Oh, she got a travel bag. Those are some interesting shoes. Number 3 had some interesting shoes. They could be like wrestling shoes. They're walking. That's a big dude. And he's still walking on the back of his pants. That's interesting. They're walking in order. The same order. I guess it makes it easier to sit down when you just like file up there. McCray H says, Jeff, why are you still awake? Again, people make the assumption I'm still awake. I'm not still awake. I'm awake. I slept for 6 hours before this thing started. I'm just awake, not still awake. I had a very, very good sleep. Actually, longer than I normally sleep for. Ah. Okay, I thought dude, Mike, come on. Can we hear? Hey, law and crime. Law and crime, come on. Really? Hey. Yeah, we see the muted. Hey, Law and Crime, thank you. Thank you for like tuning out for the closing arguments of this case, you idiots. Let's see if anyone is mentioning to them here. Sound, it's Monday, muted. Sound is no sound. Dude isn't using a mic. No, that's not the problem.
How strong that fort seemed the day you built it, maybe the next day. Inevitably, the sun came out.
Why is the defense going first?
That fort that appeared to be so strong looked like it would never collapse, never fall down. Every single time it did. Every time. The Commonwealth, in this case, bears a heavy burden. They admitted it in their opening. They bear the burden to prove to you every element beyond a reasonable doubt. And at times, they have seemed to have built the strongest, toughest fort that was going to last forever. I want to suggest to you that when you look at it and really think about it, it isn't so. Your job, and we talked a little bit about this when we were selecting the jury, it's not just one thing, it's multiple things. The most important thing that you do is you try to make sense from this witness stand.
That's what it seems like.
Of what really happened. You take the pieces of evidence that you have.
Ends won the coin toss.
And you evaluate them. Decide which parts have credibility, which parts don't. When you're thinking about their case and you're thinking about what they proved beyond a reasonable doubt, that's what you have to go from. The evidence that you actually heard from the witness stand. Because the other part of your job, and there's the reason there's 12 of you, right? Because you caught something, maybe you missed something. You caught something else, maybe you missed something else. And that's why you get to talk, right? You're not going to do separate analysis. You sit in a room together and you have your notes. Some of you took a lot of notes, some of you took a little notes. That's up to you, right? That's your business. But you get to talk to each other, and you'll have the instructions from the court. And the instructions from the court are very important.
I like the way you think,
That's
MG.
why
I
not
like the
only
way you
does it read
think.
them out loud, but each of you gets a copy.
That's
Those
I like the way you
represent the
think.
actual law, the law that matters in this case. And then you get to do something that's sort of amazing. You get to apply the facts of this case to the law. That's part 2 of your job. You get to say, okay, now we've decided what happened. We've done the best we can to figure it out, right? And now we look and we say, did the prosecutor, did they meet their burden? Did they prove beyond a reasonable doubt? And then if they did, what did they prove? Because as the court read to you, there are multiple possible options. And then you're the ones who choose. Now, I'm going to talk to you for a little while, tell you what I saw, what I observed, what I think. Prosecutor's going to get up and do the exact same thing. Okay? What I say is not evidence. The prosecutor says it's not evidence. What you heard in the witness stand, that's the evidence. So let's talk about credibility for a second. You really heard 2 types of evidence in this case. You heard a lot of evidence from either police or people who work with the police. And then you also heard evidence from the other suspects. I'm going to talk about those separately. Because I want to be clear. I want to try and be as clear as I possibly can. There were a lot of witnesses who either were police or worked with the police. And they told you little pieces, really. No, there's a little piece, sort of like a puzzle, little piece here, little piece there. Sometimes they fit, sometimes they don't. The prosecutor's going to tell you that they all fit. It all makes sense. It's clear, crystal clear. It's not. You know them. You sat in this room. You heard the evidence from that witness. In their opening, the prosecutor talked about, I want to get this right because I wrote it down, a monstrous bloody scene. I think those are the exact words the prosecutor used. Monstrous bloody scene. What we heard from the witness stand, that was not true. What we heard from the witness stand is that there was an entire bunch of officers with a search warrant who can look at whatever they want that's on that search warrant, right? And went in the scene in Hyde Avenue, right? We heard a lot of evidence. And they walked through and they didn't see much of anything. They walked through and they left. They took off and were gone for, though there was a little quibbling about it, it was about an hour and 45 minutes, something like that, before they decided they were coming back for the new search warrant, right? This was no monstrous bloody scene, blood everywhere, any of that sort of stuff. And we know that from the actual testimony we heard on the witness stand. But that's not what the prosecutors want you to think. They want you to picture it different. I'm going to ask you to remember what the real evidence was from this real witness stand. We heard that the police weren't even able to videotape the scene. It sure would have been helpful.
Yeah.
All of you.
Sure would have
It's
been.
helpful to me. If there had been a videotape showing us what it really looked like that first time they went in, or the second time they went in, they said they had new evidence. They're going back 2 hours later, approximately. And on the third day of trial, we get handed a videotape, the missing videotape, which is completely, utterly black. Doesn't show. That's not helpful. That doesn't help you. It doesn't help me, doesn't help anyone understand anything. Right? It's important to remember what you actually saw, what we actually learned from the witness stand. You know, there was right here these photos that I tried so hard to find the other day. Found them in advance. You know, there was all the testimony. We saw it on the big screen. This dramatic, lighting up blue. And that's the drama. And you see it, and it has colors and lights. But the actual testimony is that none of this was blood. That's, I'm going to suggest to you, that's smoke and mirrors. I don't know what showing you these photos where stuff lights up and then it turns out it's actually not evidence. That is not helpful. It's like anti-evidence.
Anti-evidence.
That is not
I like
something that is useful or helpful, and it definitely is not something that helps them prove anything beyond a reasonable doubt. It's the opposite. But it is concerning when people get on the stand and they talk about their degrees and they talk about how hard they worked and they did these things, and then they act like they found something when they really didn't. It's always weird when to stand up here and beat up on the police, right? Police do good things, they also do bad things. We know it, right? We all know it. Anybody reads the newspaper knows it. They're not perfect, they're not completely imperfect.
Not completely imperfect. What does that even mean? Not completely imperfect. I'm confused.
I don't know. Maybe it's normal.
It means something,
to not
I
do a
guess. I don't
report
know.
For 2 years.
Huh. All right. Whatever.
Try and do it from memory 2 years later. All this time later, try and get those facts, and then come into court and act like they know what happened. Maybe that's normal. Seems a little bit weird.
She needed to have done this. Oh well.
But we know from this witness stand that that's the sort of thing that was happening in this case. That one officer said when he had to fix something in his report, he went and did an addendum and typed it all up and showed right up. That first detective who talked to us said it's impossible. Once it's down there, it just stays there. And that was his explanation for how he made a big mistake. How he said there were 6 shots when there was actually 1 shot. He said, I couldn't possibly go back in and fix it. It's been 7 years. Couldn't possibly do another report that explained something as important as 6 shots, 1 shot. I know that's not 6. I don't have 6 fingers. But what are some of the other things, some of the really big things, some of the very important things that were alluded to, but not really explained from this witness stand? They told you, multiple witnesses, most recently Detective Tinelli, but multiple witnesses told you that there were other adults at Hyde Avenue that night. Detective Tinelli said there was the dark-skinned man and the light-skinned man. There was also a Caucasian woman. I think they finally sort of agreed that the Caucasian woman had left before much happened, maybe, but she had been there. They're unable to figure out who this person was.
I am in Busan, South
To
Korea.
me, why, when they have Carter and Taylor, and we're going to talk a lot more about Carter and Taylor, why Carter and Taylor couldn't inform the police who this missing woman was. I would have liked to hear from her. I would like to know. I have investigators who work for me. If the police don't want to interview her, I want to interview her. I want to know what she has to say. Because I don't think that what we heard on the witness stand about Hyde Avenue is honest. I don't think it's correct. I don't think it's credible. I don't think it's true. We don't get to hear that. But we also heard about the light-skinned man and the dark-skinned man. Now, Detective Tonelli said, well, we just never were able to figure out who the light-skinned man was. I can't invent somebody. Remember? It just happened, right?
Mhm.
Friday.
Yeah.
But he didn't say he didn't know who the dark-skinned man was. In fact, he told us who the dark-skinned man was. Why in the world was that man not on this witness stand? There's another eyewitness to all of this, and he knows who he is, and we never heard him. Never heard what he had to say.
Why was he not charged?
That doesn't make any sense to me at all. Just gone. The police were picking and choosing. The government was picking and choosing what they showed you in this courtroom. Now, the police had already decided who they wanted to charge. They already had their guy. No matter what you think about the police, good, bad, or in the middle.
Were they talking
Police
about
think
Coleman?
They got their guy. That's what they do.
Was Coleman the dark-skinned guy they're talking about?
Sometimes they're right, but sometimes they're just wrong. But they are tenacious. I don't know Detective Tonelli, and I'm not up here trying to say I do. Never met him before this trial started. He strikes me as someone who had made a decision and decided he was going to charge Brice Rhodes no matter what. And then he did. And then he stuck to it no matter what. I want to suggest to you that that is not the way our legal system is supposed to work. The good news is that final 12, and it was 14 of you now, who sit on this case act as a check to that. Because no matter what the police think for the last 7 years, no matter what they did for the last 7 years, no matter what the prosecution thinks, it's your verdict that counts. You know, when we're talking about things in this case that don't make sense, it's funny. I have kids. After a while, even your kids do or say the same.
I thought he said he had
false
kitties.
stuff. After a while, it seems normal to you.
What?
My kids pronounce the words "I love you," "I love boo." That's just how they pronounce it. After a while, it seems normal to me. I type it like a made-up word, just for my family. Right? That's normal to me. That may sound like a strange thing to say, but
It is,
what
yeah.
I want to explain is that the folks involved in this case have been hearing the same story over and over and over again. And after a while, it just starts to, it must make sense. I've heard it for 7 years.
Oh, don't say that. Don't say you've heard this story that makes sense for 7 years.
Christopher Jones does not make any sense. I hope with your fresh sets of eyes and your ears, you heard that. And the first time you heard it, said, what? What? This doesn't make any sense at all. It's a fake or made up hit on someone where maybe the wrong person gets, it doesn't make any sense. This is not a plan. What kind of a plan is that? They couldn't make it make sense on the witness stand, and they tried a little bit. And then, when it wouldn't make sense, they just passed the buck. But you know what it does sound like? It sounds like the sort of story, sort of explanation that would get cooked up by two teenagers when they're trying to come up with some version that makes them look a little bit good. Or maybe I should say less bad. Doesn't make any sense. And when I say two teenagers, of course, I'm talking about Taylor and Carter, two cousins.
No, the defense rested right before this.
Time to come up with something, both before their arrest and then time after the arrest. I have to talk about this car seat. I don't even know what to say about the car seat. It's so bizarre, it stands out like a sore thumb. But when the prosecutor's trying to say, our police officers, had the highest level of integrity, and honesty, and professionalism, and you should take for granted all of the testing and all the evidence they collected, I want to suggest to you that the car seat really explains why you should not. We certainly don't have a car seat. We don't have one in this courtroom. You never saw one. I never saw one. But the police, under oath, said, we got a car seat. Said it a couple weeks later. Then a month after that, they were under oath again. And they said, we got the car seat. And they're writing, Detective Tonelli says, write this police report. After that, he's got a car seat. Now, I know he's saying there's a lot of evidence, it's hard work, can't know everything all the time. I hear that. But there's a few problems with it. One is that when somebody testifies under oath, like in this trial to you, you have to be able to rely on it. That's why we have people testify under oath. They're supposed to get it right. It is their job to get it right. And if they don't get it right the first time, we certainly expect them to get it right the second time. If they don't get it right the second time, we don't expect them to put it in their police report, which gets sent to all of us, so we can do our job, so we can have the evidence, so we can explain everything as best we can to you. But that's not really the part that's a shocker. The part that's a shocker is 3 years later. You can have all the excuses about overwork and lots to do and everything, and I'm sorry I testified incorrectly under oath, and I'm sorry I testified incorrectly under oath again, and I'm sorry I put it in that report and I didn't fix it. But none of that holds water 3 years later. He said, I didn't realize until the fall of 2016. Okay. This is going to be up to you to decide how much slack you want to cut him. It is. It's not me. It's you. I'll tell you this. 3 years later, in this courtroom, when he tells a judge, a different judge, but a judge in this case, we've had cases we've gone so long, we have had changing judges. When he tells a judge in the courtroom, when we're having a whole big hearing, like you heard, on all the evidence, what's the biggest piece of evidence? He says, well, I guess it's going to be the big car seat that I bring up here. He told you under oath that he didn't realize what was really going on until the fall of 2016. How can that be correct when he's still saying we got the car seat 2019? The prosecutor may get up here and say, everybody's overworked and sometimes people are stopped. Sometimes the police is slow. If that's the case, what else was done sloppy? If sloppiness goes to the point of incorrect testimony under oath, how can we judge the credibility of the evidence that you have seen? It raises serious doubts about the credibility. Judge even read an instruction that went to you about tainted evidence in this case. It's not just the defense attorney up here talking to himself talking. That's the law from the judge in this case. But what I want to talk to you about, what I think the most important thing in this police investigation, part that literally woke me up last night thinking about it. It's not the car seat. It's not. They probably thought it'd be the car seat, but it's not. But you know what I really would like to know, and what I think all of you have a right to know?
What's that?
I want to know about that truck. That burned truck. That stolen truck. I want to know a lot about that truck. Where was that truck stolen? I want to know when it got burned. I want to know where it got burned. And most importantly, I want to know why it got burned. Because I'll tell you, there was an awful lot of mud thrown at Brice during this trial, but nobody ever tried to say he stole the truck, drove the truck, he burned the truck. You never heard those words from anybody. Why in the world did that truck?
Because the defense doesn't have to ask about it. The
Why don't
prosecution
I know more
should
about
be-
it? Why don't you know more about it? Why didn't we hear more about it? Why didn't the police seem to care about it?
I'll be right back.
So
It's
what do we
getting
know?
cold in
What
here.
do we know under oath from this witness chair? Well, we know that Carter said he stole it. We know that Carter and Taylor said that he stole it and drove it on the night of Christopher Jones' murder. But we also heard Carter say that he hit Jones with the truck. Now, the ME talked about blunt force injury. I don't know if that's from the truck or not. I have no idea. I know he had blunt force injury to his head. It might be, it might not be. I don't know. Prosecutor might have some opinions about that. They may not. I don't know. But he had an injury to his head. But what I do know is that Carter said he hit him with the truck. He said he hit him while he was down on the ground with the truck. He said he ran him over. The prosecutor asked him, I don't remember the exact question. He asked him something along the lines of, well, you know, by mistake. And he said, no, I hit him with the truck on purpose. That's the prosecutor's witness. That's the believable, credible person the prosecutor has put on this witness stand, is a guy who said he hit poor Mr. Jones while he's on the ground with a truck. For what reason? I don't know. I have no idea. I think the prosecutor didn't know he was going to say that. I certainly didn't know he was going to say that. We know that about the truck. Do you really want to know what I want to know about that truck? I want to know if Maurice Gordon or Larry Ordway's DNA from that truck. Because you remember from what we heard from the witness stand, their DNA was not in the Mazda. There's so much talk about this Mazda, but DNA wasn't in the Mazda. But from what I heard, there's this truck being driven by someone who has confessed to being involved that is burned. We don't know why. We don't know when. That never got tested. I want to suggest to you that maybe that truck is actually what was driving the two bodies of those young men around. Does that sound like idle speculation? I don't know that it is. Because why did he burn that truck? That night, there's all this talk about people trying to burn evidence, right? Was the truck burned the same night? The perfect and logical reason for burning the truck would be, in fact, that it had been used to transport the bodies of those two young men. Think about the story that Taylor and Carter told about how the bodies were removed from the house. I listened to it again. They're putting totes, those big blue bins. That's what they described. One of them said the sort of thing you put your Christmas ornaments in. If it's big enough to fit a person, it's not going to fit in the trunk of a Mazda. And we don't have a Mazda. I wish we did. We'll open the trunk, take out a tote, try and fit it in. But we don't have that. But use your common sense. If all of you have had a car, anything like that, those big totes don't fit. And they're certainly not going to fit two in the back. You know what they fit in real easy? Back of the pickup truck. No problem. No problem. So you get to decide completely if all the things I just said don't matter. You get to decide. You're completely empowered to do so, right? But I'm going to suggest to you that they're worthy of discussion. They're worthy of discussion because the story you heard from Taylor and from Carter, I think is possible. It doesn't make sense. But the part that really bothers me is the lack of investigation and follow-up by the police of the truck. And I want to suggest to you that I believe it's because they had just decided who they wanted to charge. They decided and they were charging, that's it. And since he's not associated with this truck, they're not investigating the truck. That's not the way it should work. It's not the way it should work. It's not the way evidence is supposed to come into this courtroom so that it can be explained to you so that you can do your job. So let's talk for a second about Taylor and Carter's decision.
The judge is typing.
It means they know each other, they're tight. They said they were. They said they were close. How can we evaluate their credibility? Well, one way is, do their stories change? Well, yes, we know they do. police and prosecutors admit they do. They admitted that they did. There is no question that Carter and Taylor lied. The police are just saying that they like the last version. But that one's not a lie. But there's no question that they lied. There's no question they changed their story. They admitted they did. The police admitted they did. The prosecutor admitted. They changed their story. And that's one of the things that we look at and think about when we're trying to figure out if someone is credible, someone's being honest. Do they change their story? We know that specifically they lied. That's another thing we look at. Not just a changed version, but a full-blown admitted lie. They admitted on the stand that they had lied. They said they were telling the truth on the stand, but they admitted they had lied in the past. Now, Taylor said he was just trying to do the right thing. They were trying to do the right thing. I want to suggest to you that that is nonsense. How do we know it's nonsense? We know it's nonsense because when he first came in here, he refused to say a thing. If he is so gung-ho to tell you that's why he's here, he's going to do the right thing and say the right thing, then why did he refuse to say anything while you sat here? You had to leave the courtroom. He's still on the witness stand after you came back. Remember what he said? I got nothing to say. I got nothing to say. I got nothing to say. He had to be threatened in order to answer questions. That is not somebody who's just in here trying to help, just in here to do the right thing. He's doing the opposite. What he admitted when I asked him was he actually didn't ever want to be in the courtroom like this. And he didn't ever want to tell anyone because he didn't think he was going to get caught. It's going to be up to you to judge the credibility of that witness. But I want to suggest that he's not credible. He's not. He came in and told you he's not credible, and neither was Carter. Now, ironically, maybe you say, well, if Carter wasn't telling the truth, he wouldn't have admitted he hit some guy with a truck. I don't know what he was thinking in this courtroom. Incarcerated, he was the guy who had, came in incarcerated, right, testified. Think about some of the other just cold things that Carter said. Said he hit Mr. Jones on purpose with a truck, no reason. When he was holding a cell phone that he stole from somebody he helped kill, or maybe just killed, he got phone calls. He got phone calls from that young man's mother. And he kept the phone. And he just lied to her. So they're sleeping over. He actually said, when asked, I didn't care about her. It may not be an exact quote. That's what he said. He said, I think he might have said, I wasn't worried about her. That's the prosecutor's witness. These are the prosecutor's star witnesses. Confessed, admitted, actual murderers. Their final version is the best of the best. Their final version is, we participated in murders. That's the winner in the contest. They would have said anything the police wanted them to say in order to get out. And they both admitted that their testimony in this courtroom was so they could still have their deal. That's why they're here.
He's making good points, just
But I
not
wanna
very
highlight
dynamically.
4 things.
Could be a little more dynamic. They're great points.
Put them up here on this chart. Those 4 things I think are very important. I could have gone back through the versions they gave the police, the 126-page version, which is all nonsense. This is all basically jackknife. And then their later version, and the later version. But to be honest, at some point, I think it just gives everybody a headache. We have a headache already. But so here's what I did. I went back through only what they said in this courtroom. Only what they said under oath in this courtroom to you, Carter and Taylor. And I picked out 4 things. Why are they important? Because they both are claiming they're telling you the truth under oath. They say the opposite.
Inconsistencies?
Credibility. Even if all you judge them from is what they said under oath to you in this courtroom, I'm going to tell you what those 4 things are. The first thing, I'm going to put Carter here. Judge, if you need me to pivot this so you can see it.
Okay, thank you.
Yeah, I'm good. I don't need to see this.
Carter was the person who testified first.
I'm busy typing.
Here I'm going to put Taylor. Mr. Taylor testified at the end of the day on Thursday. The first thing that they testified to you about under oath that they disagreed about, we just talked about, but I think it's worthy of the list. Carter said that he hit Mr. Jones with a truck. Taylor said, no, he didn't. He got asked, he said, no, that didn't happen.
Earlier I said it was Taylor that hit the guy, ran over the guy with the car. I guess it was Anwan that ran over the guy with the car.
And the person who was driving the truck. We already talked about why I think that's important, because I think the truck's important. But let's talk about a different fact, and one that hopefully jumped out. Folks. The gun that was used, according to the testimony in this courtroom, to shoot Mr. Jones. Carter was asked point blank, where was that gun purchased? I can't ask you. I'm going to tell you what he said. What he said is, purchased in a trailer park. Said that under oath in this courtroom right there. And what Taylor said? Taylor said, I purchased it at the home of Larry and Maurice. Same gun, same day. Both prosecution witnesses under oath. There's no wiggle room there. One of those 2, I'm going to write it up here. Specifically, he said he purchased it from a relative.
You can't
don't
make
know all the
spelling
details
errors when you're gonna
of
do it like
purchase.
that, dude.
But I was surprised when under oath, the prosecution's second witness had a completely different version of those. Not some far off 7-year ago statement. Folks, we're talking about Tuesday and Thursday. No, Wednesday and Thursday. Those statements are made 24 hours apart. Somebody's lying. Somebody's lying to everybody in this courtroom, and most importantly, that means they're lying to you. Prosecutor may say this next one doesn't matter. I think it does. Remember all the testimony about the vote? I'm going to call it a vote. I'm not going to quibble about the vote. It's people talking about whether or not someone is going to be killed according to the testimony. Pretty serious stuff. The kind of thing that you want to get right if you're testifying about the details. Mr. Carter said that he was the only one who said no. And he was asked specifically about Taylor. And he said, Taylor voted for death.
Mm-hmm. This is the one inconsistency that I mentioned earlier.
Taylor didn't even mention it when the prosecutors were asking the questions. He didn't even bring up the conversation. When I asked him about it, he didn't want to call it a vote. Don't call it a vote. I don't care what you want to label it. But he didn't want to talk about it at all. When push came to shove, he testified under oath that he voted for life. He said, no. They can't both be telling the truth. Carter said Taylor voted for death. Taylor self-servingly told you all he voted for life. Why do you think Mr. Taylor didn't want to tell you what really happened? Maybe it's because Maurice threatened him with a knife. Remember what Mr. Taylor told you about that knife? Mr. Taylor said the same knife he got threatened with by the victim was the one he held in his hand when he stabbed the victim. Same knife. Taylor has something to hide? Yes, he does. He admitted it. He was angry. Of all of the testimony, he's the one with an actual motive to do violence on that night. And the last, but very significant difference is about those Timberland boots. The boots. What did Carter tell you? Carter said Taylor stole boots off one of the victims. That's what he said. Taylor stole boots. I bet you remember what Taylor said. And I bet you remember because I bugged him about it and asked him about 12 questions about it. That he said, I didn't steal any boots, those were mine. Taylor said they were his. He didn't steal anything. Those were his. You know the problem with that? No matter how much these guys put their heads together and came up with a story, they did it 7 years ago. Their story from 7 years ago is going to have pieces that they never talked about. And also, 7 years is a long time. Always a few pieces here and there. funny thing about the truth, you don't have to hold on to that quite the same. You know, if somebody tells me a story and it's true, I'm gonna expect that if they tell me that same story 5 years down the road, it's gonna be pretty much the same. Now that I might ask it different, they might tell it a little bit different, but it's not gonna have these sorts of whoppers.
Stop coughing in my ear.
And you know what else they didn't have the benefit of when they were putting their story together? They didn't have the forensics reports. Because when Mr. Taylor is saying, I didn't steal those, I own those are mine. Detective Vance told you that they belong to the victim, right? I asked Detective Vance, I said, Mr. Carter had an item that belonged to the victims. He had the phone. Detective Vance said, yes. I said, Detective Vance, Mr. Taylor had an item that belonged to the victims. He had these shoes. Detective Vance said, yes. Then I said, and Brice Rhodes didn't have anything that belonged to the victims. Detective Vance said, yeah, that's right. He didn't. But what else do we know about those boots? We know they were tested for DNA. They were tested in multiple spots. We heard the testimony from the DNA folks. And guess what? Mr. Taylor's DNA isn't on his own boots. Oops. It's on his boots. Stolen. Just like Detective Vance said. He's in here trying to, well, good. He's in here trying to protect himself and cover himself. And he doesn't want to tell you the truth. When you're evaluating the credibility of the witnesses that you heard from this witness stand, remember these things. Testimony under oath spoken to you within 1 day. And it can't be true. They can't both be true. We already talked about Mr. Taylor and the knife. You know why they're in here. They're in here because of these. Now you have copies of these. These are yours, right? Everything that got marked as exhibits. It's mostly a lot of photographs, to be honest. These are going to go back, and you can have them. You can look at them as much as you want, right? But I want to suggest to you that you really do look at them. Okay. Those two witnesses, the ones who confessed to being part of murders.
My mic is hot because I'm hot. Something like that.
Who we know lied. Nonetheless, this shows what they were looking at was up to life in prison on each murder, on each one, looking up to life. And what did they get? Because they're willing to come in here, they're willing to say, the police wanted them to say, in this courtroom, it got reduced from life in prison for each murder to 5 years. 5 years.
All right, let me check to see how out of proportion my mic is.
That's a pretty big drop. That's a pretty big motivation. Just to make sure that they stayed motivated. In this document, it says, even after you serve your time, and you're out, and you're done, you still have to come back to this courtroom.
Very is the answer, apparently.
And if we don't like it, we want to say that we don't think you told the truth. If we can convince a judge that you didn't tell the truth, then you're back at life in prison. Times 3. So you better do your job and get in here and say what you got to say. Some black So all of this, we're talking about credibility, all of this matters. Because you're going to have to decide whether or not the prosecutor really proved beyond a reasonable doubt their case. So I want to stop for a second. Why do we even have that? Why does that matter? Why is that the rule? We have that rule because there used to be a time that the police and the prosecutors could literally go out and grab somebody if they didn't like them. Grab them if they just thought that they were guilty. And then there was stuff. There are legal systems where you are presumed guilty and you have to prove your innocence. That's horrible. And one of them is Iran. I don't ever want to get arrested in Iran. I have nothing against the country per se, but that legal system, I don't want anything to do with it for a variety of reasons. Imagine how horrible it would be if the police got to say, I think you, I don't want to.
Oh, geez.
I think you
That was
did.
a
This is what we think.
that was a death rattle.
From now on.
Oh, Judge, come on.
So you can prove you didn't do it. How horrible is that? We made a choice in this country and we live by it, and we have excelled because of it. That the government doesn't just get to do whatever they want and charge whoever they want and arrest whoever they want. Because when they do, it may take 7 years, but finally they end up here. And they end up with you. You are here to make sure that it's not a guess. Beyond a reasonable doubt, it's not a maybe. It's not a probably. It's beyond a reasonable doubt. Now, I'm not going to try and tell you what a reasonable doubt is. I'm not going to try and define it. That's up to you to decide. But it's a big deal. It matters. Didn't matter, you wouldn't be here.
Oh, come on, Judge. Jesus.
I'm going to ask you to remember all the way back, and I said it once before, that there are two jobs. When you go back into that jury room, your first job is going to be to figure out the best you can what the prosecutor proved beyond a reasonable doubt. Then, I'm not going to, the judge will read them all. I'm not going to read them at you. I'm not going to, you guys can all read them if you want to. Fine. But to apply the law and the instructions to what you believe the prosecutor proved beyond a reasonable doubt. And I'm not suggesting that's easy. Right? It may take a while. I don't know. It's going to be up to you. It's going to be up to how the foreperson, frankly, runs the show back there a little bit. But I have complete faith that you have. I've watched. You're all paying attention, taking notes. I think that you will do both halves of the job back there. And I appreciate that you're going to do it. I'm going to ask you when you're doing that to remember the credibility of the folks who testified, and remember all the other things you know about the investigation. Things can't be, shouldn't be taken at face value. In the final analysis, the prosecution did not meet their burden. I think the police always assume the government assumes that if they can put on a big enough show, bring in enough people, that the jurors will just fall in line. Don't do that. You make your own decision, and I'm not going to tell you what it is. But you're more than just pawns for the police. You're the jurors in this case. And what you do matters.
Move my microphone out of the way there.
In the final analysis, the prosecution did not prove beyond a reasonable doubt the existence of an intentional murder that involves Brice Rhodes. It did not. Now, if you look at those instructions, in there, it's a definition of wanton. It's a word that probably none of us ever use, but it's a word in our language and the law likes it. So that's why it's there and you get a definition of it. Try and make more sense out of it. That one's a little bit more wide open because it covers an awful lot more territory. Just because it's wide open and may seem more like the prosecutor met their burden there, it's not. You will decide. And there are two different offenses that both require wanton rather than intentional. Again, that's all written down. Judge read it. You can look at it as long as you want. And hopefully it will make sense. There's 12 of you. That's how it doesn't make sense to one person, makes sense to somebody else. But I'm going to ask you, let me go back.
All right, Judge, come on. You got to stop this.
All the evidence you heard from this stand about a lack of credibility of so much of that evidence. To return a verdict of not guilty.
Mr. Griffiths, thank you. Ms. Jones-Brown, would the state like to make a closing argument?
All right. Well, that wasn't fantastic. It wasn't horrible, but it was a good solid B minus maybe. Japanese Yakuza 1 says it should say I try to be a bit more nice, but me drunk and spelling doesn't mix. And Emily G, the lady defense attorney, should be giving the closing arguments, in my little old opinion. Jesus Christ. Why? Between the judge and that squeaky podium. Any other noise you want to
Ladies
make?
and gentlemen of the jury, it was Brice Rhodes who decided that Christopher Jones.
How to fix my ear problem? Thank you so much.
It was
I
Brice Rhodes
just
who
waited.
shot him.
Nothing. Just waited for a
Brice Rhodes who
day.
decided that Larry and Maurice had done it. It was Brice Rhodes who stabbed them over and over and over. It was Brice Rhodes who gave the knife to Anwan Carter, to Ja'Cory Taylor, to Tyron Coleman, to the unknown man, to make sure they were all in it. He learned his lesson last time about people talking. It was Brice Rhodes who took those bodies to River Park and burned them. There are so many profoundly tragic parts of this case. I don't know which is the worst. There's Christopher Jones, father of 3, crossing the street in the West End, nothing to do with any of this. Shot dead for the stupidest of reasons. Larry and Maurice, killed because they did what we would want any teen to do in this circumstance. Go to your mom. These 4 children, so desperate for adult male guidance that they keep hanging out with Brice Rhodes even after they became scared of him because of Christopher Jones's murder. There's Ja'Cory, who had nowhere else to go, sleeping in stairwells, going over there even when he didn't want to, because that was a place where he could spend the night. Maurice tied up with a sock in his mouth, bound, knowing his little brother's in the bathroom. Larry stuck in the bathroom. not knowing what's going on outside, we hope. And then Larry struggling when he comes out and sees the blood on the floor. And Ron Carter and Ja'Cory Taylor feeling they have no other option but to follow the orders of that man who forced them to participate in the murder of their best friends. Forced them to clean up after, forced them into this life that they now have. Arrest, prosecution, juvenile custody, adult custody, felony convictions, prison, having to come to court and testify. That is what this man has done to this entire group of children. Now, how do you know, based on the evidence presented here, that Brice Rhodes is guilty? A lot of it does have to do with the statements of Anwan Carter and Ja'Cory Taylor, but their statements were corroborated by other evidence in this case. So let's go over what we have. First of all, this case is charged in complicity, and you'll have this definition with you. It's on your jury instructions. But it means that you don't have to worry about who stabbed the fatal stab. If you believe that Brice Rhodes orchestrated this, if you believe that he was in on it, if you believe that he was commanding or soliciting or engaging in conspiracy with them, you don't have to worry about what stab wound killed them. He is guilty of the whole act. To return to how do we know he is guilty, we will start with the murder of Christopher Jones. Now, Anwan Carter told you he was following behind the blue Mazda. He knew that Rhodes was in the driver's seat, or the driver's side rear seat. He saw Rhodes shoot out the window and kill Mr. Jones. He admitted, Mr. Carter did, that he drove over Mr. Jones. And Dr. Lippincott told you that there was a wound on the head, a bruising that could be consistent. We don't know if that head bruising was caused by running over. But whether it was intentional or not, we know that Mr. Jones would not have been in that road lying prone to get run over by the pickup truck if Brice Rhodes hadn't just shot him. So again, complicity, he's in it. Now, Ja'Cory Taylor told you he was right next to Rhodes, inside the Mazda when Rhodes shot and killed Christopher Jones.
Stop the car. He sees somebody on the street. The Brice told him he had to shoot him. Shot him.
Who shot him?
Brice.
Brice Rhodes shot him. Ja'Cory Taylor told you he saw Brice Rhodes shoot him. Now, both of them described the Mazda in front, the pickup truck behind, and you saw on the Ring video that Detective Griffin found on the block that night, from that night, that there is a small car driving past, immediately followed by a pickup truck. And that tells you that they're not making this up. Ja'Cory and Anwan aren't making this up. Again, the shots that night, the one shot followed by 5. You heard that came in on the 911 call. Somebody said one shot followed by 5. Anwan Carter told you that after Brice Rhodes shot Christopher Jones, they drove down the block a little way and he fired off about 5 shots at a house. One shot followed by 5. Now the defense pressured Detective Griffin on, why didn't you change the report when you only found one casing on the street? This is an example of why you don't change a report. Because it is a fact that the 911 call came in that way. Then later they talked to Anwan Carter. They find out why there are 5 shots following. And this goes to show that they're not making this story up. Anwan Carter was there that night. He wouldn't have known about the one shot followed by 5 that came in on the 911 call unless he was there. Now, this, he was in front. Jacory was in front in the Mazda. I don't know if he turned around, saw what was happening, and makes total sense that he wouldn't have seen. He just saw Brice Rhodes kill a man. Makes total sense that he didn't turn around and see what Anwan Carter did with that car. So we know that they were there. I guess the defense wants you to believe that these kids just, took a Mazda and a pickup truck over there to commit this murder for no reason? That's what doesn't make sense. 15 years old, Larry was 14. And so Larry 14, Anwan 15. Then you have Maurice 16, Jacory 17. But these 4 teenagers drove over there. They were there because Brice Rhodes brought them there. And the rest of the story doesn't make sense except how they told it. Larry and Maurice started telling their mother Brice Rhodes was mad about it and he killed them for it. This crime had an effect on these kids, as Jacory told you.
He don't see nobody like get shot. I'm not gonna lie, it was also, it wasn't just him too, it was also. All of us.
You were scared?
They both sound really disinterested. Both people do.
The words and emotions of Jacory Taylor, now age 25, having been to prison, having lived 7.5 years since that day. It affected him. It affected Maurice and Larry. And the defense pointed out that when Jacory Taylor first came in here, he wouldn't testify. He started to, then he stopped. It took a while. As they said, he was threatened, but that was with contempt of court, the same thing any witness has to abide by. You come in here, you have to testify when you're under subpoena. He was here for what is possibly the scariest thing that happens to anyone, to come into a courtroom, to talk about what happened, tell about something that's horrific, public speaking. And he had to do it in front of the defendant and in front of the families of the victims. So it is no wonder that he was scared, that he was emotional, that it took him a while to get there. So they were scared. Larry and Maurice told their mom. Did he tell you what did he do to them?
So we gotta kill him.
Brice Rhodes said, we got to kill him. And we'll talk about the instructions later on, but this is how you know it's an intentional murder. He told them they were going to go kill somebody with Brice Rhodes. And it being Christopher Jones. And look, we have no reason to think that Christopher Jones had a price on his head, and I'm not saying that the person who did have a price on his head, if that person exists, deserves to die either. No one deserves to die that night. He told that there was a person with a price on their head, and that's why they were going down there to collect this money. You heard from Anwan and Jacory that the money was never distributed, so we don't have any proof whatsoever that Mr. Jones was anything but crossing the street. But that was Brice Rhodes' intent, to kill Christopher Jones, and this is his intent, to kill Larry and Maurice because they were telling. All right, now we come to Saturday, May 21st. Christopher Jensen told you that Rhodes borrowed his car that day, the Dodge Charger. Rhodes admitted in a statement that he probably was in front of Larry and Maurice's house in that car. Later, you have Jacory Taylor and Anwan Carter riding around with Q. They stop by Maurice and Larry's. Boys aren't home. They eventually head over to Rhodes's. Q drops them off. Imagine how relieved Q is that he decided not to go in there that night.
She's got to do something about that.
So
cop,
Anwan
for
and Jacory
God's
arrive.
sake.
Everything's fine at first. People present are Rhodes, Larry, Maurice, Tieran Coleman, unknown male, unknown female. I have a few things to say about that while we're here. The unknown female and the unknown male have never been identified because Detective Tonelli has nothing to go on with their complexion and their gender. These were a 15-year-old and 17-year-old witnesses at the time. They went into a house. They weren't introduced enough that they retained names from this situation, if they were introduced at all. Hung out with these people. Female left. The other guy stayed, but they couldn't describe him any more than light-skinned male. So Detective Tonelli can certainly not go rounding up every white female and every light-skinned male in this county, nor do we want him to. He could not continue that investigation without more to go on. But Anwan Carter was able to give him more about Tieran Coleman. At the time, he was describing him as a dark-skinned male and was able to point out a rap video, local rap video that fellow had appeared in. So based on that, Detective Tonelli was able to build a photo pack, show Anwan Carter, he identified it, and then the investigation into Tieran Coleman took off. So with enough information, of course, he continued the investigation. He would have liked to have done it with the other individual, but he did not have that extra clue as to what direction to take the investigation in. Now, Tieran Coleman is obviously not here. You know that his case is being handled separately. If you believe the rest of this beyond a reasonable doubt, then that's one of those things I talked about in voir dire. Sometimes you do have questions. You're sitting there in the jury room, you might be like, well, I really would like to know why Tieran Coleman wasn't there. If it's not A or B or C on the jury instructions, if it does not affect your reasonable doubt of those questions, set it aside. It's a question that you can ask afterwards, but do not let it affect you now if you believe everything else beyond a reasonable doubt. All right, to return to the events of that evening, we heard from both Anwan Carter and Jacory Taylor. Jacory and Maurice got into it. Maurice grabbed a knife. Jacory jumped back. Brice Rhodes took the knife from Maurice and hit Maurice. He then powwowed with everyone else. What Anwan Carter described as a vote and Jacory described as a conversation. Anwan remembers being the only one. Jacory remembers that he and Anwan did not want to do it. I don't know how he was phrasing things. I don't know what Anwan picked up from him. They are both telling about their memories. I skipped over this one. Purchase in a trailer park. I don't remember that, but if you do, go with your memory. But obviously, as far as the events of that night with how this.
Now my neck is hurting from keep looking up at the camera for 4.5 hours, just putting my head down listening.
Anyway, votes.
But I do have a hard out in about an hour. I gotta go to work.
What is important from that is that Brice Rhodes was still planning to kill them. He still had the intention that they die that night, but he wanted to make sure that everybody was involved. So he tied up Maurice, had Jacory punch him in the stomach as a violation, discipline, I guess. And then he began to stab Maurice over and over.
How many times did Brice Rhodes stab him? Where did he stab him? Was he standing up or was he on his knees?
It's on his knees.
And he stabbed him in the chest. Chest, stomach. His chest, stomach. On his torso.
He stabbed in other places. How long did this go on for?
Until he stopped breathing. You saw the autopsy photos. You know that he was stabbed over and over. Larry was in the bathroom. Rhodes dumped Maurice by the door and had them bring Larry out. And he stabbed Larry over and over. And again, you've seen the autopsy photos. We'll have them back there. I don't want to show the courtroom, but we heard the testimony.
Did you know what happened to his brother? Was there blood in the spot that he was at? Did he respond to that?
Kick everything off. Get his hands intact. His hands free still.
Was his brother making any noise at that point?
Yeah.
So how many times did he get stabbed? Just stabbing.
He stabbed until he was dead.
Brice did.
He passed the knife on him.
Who did he pass the knife to? Why did he pass you the knife? They're both dead, right?
Yeah. We all would be in. So no, it's good.
He said we're all going to be in it. He wanted it to be on all of them now. He had learned his lesson on people talking. Corey's description was similar. Who's there, Maurice? Was Maurice tied up at that point? What was used to tie him up? Okay, who did the tying?
Somebody else that was there on. So he was tied up. He was silent.
Where did you see where he was stabbing him?
Stuff like that.
Do you know how many approximate times it was?
It was a lot.
What was Maurice doing while this was going on? Who was in the room while this was happening?
Yeah. It was me, brother. Brice, two other people. He's pretty much fighting, you know. Like trying to, he made him one stab. Once he had one stab, he moved to the door. He had me staring at him.
You were standing by the door?
Two other people that was in there, I didn't really know. They was already there. Yeah, so I'm thinking that, you know what I'm saying? My man, I can't do nothing, stay in there. Or if somebody's gonna do some hustle, I'm trying to interrupt the thing. So he kind of took my wrist to the door.
Dr. Lippincott told you that the cause of death was multiple stab wounds. She said Larry had 21 stab wounds. You can see in Maurice's autopsy photos that he has 8 to his abdomen alone, other wounds to his back, other areas of his body. Dr. Lippincott told you the areas, abdomen, torso, pelvis, back, groin, genitals. Rhodes made Anwan and Ja'Cory clean the house while he took the bodies over to River Park and set them on fire. He later drove the boys around to various dumpsters burning evidence. The knife was never found. We introduced photos of the knives that were collected to show you that police collected what they could find. We don't know, maybe those are the murder weapon. I don't think so. They don't match the description. They drove around different dumpsters that night, setting different dumpsters on fire. I would assume that's where the murder weapon is. As Detective Peters told you, there were approximately 7 reports of dumpster fires that day. And by the time 2 days later that he was
anyone
checking,
report this case as being a
most of them
dumpster
had already
fire?
been emptied. It's actually amazing that the pink blanket with Maurice's DNA on it was located. Anyway, that night, they noticed the back seat was bloody. So Rhodes tore it out and dumped it behind someone's garage, as Anwan Carter told you.
Prove it.
Before I turn the page here,
Prove it.
whether Taylor stole the boots, he said that he and Maurice both had those boots, that they started at his head, he went up to Maurice. He didn't remember how the boots got there that night. He took the boots at the end of the night, and they had blood on them, which is all part of the investigation. Now, yes, their stories are inconsistent on these points. I think there's an explanation for each one, but I also think this shows you that these stories were not concocted. They didn't sit there and memorize each other's statements. They came in here and told you about something they remember from 7 years ago. And these are all minor points, sorts of things that would become fuzzy after 7 years. The things they did say, the things they do remember, that Rhodes tied up Maurice, that Rhodes stabbed Maurice, that Rhodes made them participate, that Larry was stuck in the bathroom, that Rhodes tied up Larry. Those are the things they remember because that's what you would remember from all of this. All right, we've heard a lot about the police investigation over the past week, so I'm just going to summarize because I know that you all took in all this information, witness after witness. The response to River Park, the lack of any identifying information on the victims, how the police were trying to figure out who they were. It was not until Olmsted Academy contacted police and they realized that it was Maurice and Larry that the case moved forward. Detective Tonelli went to Elizabeth Wren's house, spoke to her brother TJ. TJ Wren led Sergeant Vance to Brice Rhodes' address on Haight Avenue. Vance saw Rhodes go into and out of the apartment and then followed him until they could take him into custody. In the defendant's interview, he admitted knowing the boys. You might have noticed, though, that he chatted with the detectives for quite a while. They were phrasing it as a missing persons conversation. Chatted with them for a while before he said, "Oh yeah, TJ told me they were dead." Which would be a little odd if he weren't involved with this. He admitted he was probably in front of their house in the Charger the last day they were seen. And yes, Detective Tonelli said that was on video, and it wasn't on video. But that's a police investigative technique. Police don't walk into an interview room and say, "Excuse me, have you participated in 1 to 3 murders lately?" No? Okay, well, thanks for your time. They have to use techniques to get people talking, and that was one that they were attempting.
That was one?
He did admit to being there, probably. Okay, meanwhile, while this is going on, detectives are over on Haight serving a search warrant.
And no, there was no bloody scene when they walked in. Why? Because the boys spent all night cleaning it up at the direction of Brice Rhodes. They collect the knives because they know that this is a stabbing case, possible murder weapon. Meanwhile, you have Sergeant Vance and the marshals pinging Maurice's phone, finding it with Anwan Carter, who was so young and naive that he didn't know that police could track a cell phone. Anwan Carter was interviewed.
Oh,
And he didn't change his story multiple times. He changed it once. In the beginning, he told them that he didn't know what happened. Then his mother and sister arrived. He spoke to them. He asked to speak to the police again. And that is when he changed his story. That is when he told police about his involvement and the involvement of Brice Rhodes in this case. Months later, he repeated it at a proffer at the time of his plea, and in court, he repeated it to you. But it's important to note that he was already saying this long before the prosecution of the case and any sort of plea negotiations had started. He admitted his involvement, and he talked about doing anything he did at the direction of Brice Rhodes. He talked about Brice Rhodes wanting to kill Maurice and Larry and killing Maurice and Larry, wanting to kill Christopher Jones and killing Christopher Jones that night that he was picked up, May 24th. Thus the second search warrant, because now police knew where the murder happened. And you saw the pictures of the carpet being pulled up. This is not something police are going to do willy-nilly at everyone's apartment that's involved in a crime. They needed a second search warrant because now they knew that this was a murder scene. And so now they had enough probable cause to go in and rip carpet up. And yes, the video was dark that you heard from Rebecca Kimmer. They tried to get it on video. It was dark. That's why they turned to the next step, which was just taking the carpet itself and testing that for blood. The police also interviewed the person who had rented the car that Rhodes was driving that day, who happened to be his neighbor, who was able to direct police to the blue Mazda with no backseat, reeking of bleach. Both cars were processed. Other people were interviewed, some of them with no further information. There was a child at Olmsted who was interviewed, Brice Rhodes' mother, cousin Q. The next day, Corey Taylor was arrested and interviewed. Detective Peters and Metzler were finishing up the dumpster search, and later Sergeant Vance collected the boots. So what do we know from all of this? From the second search warrant, we know that the carpet was covered in blood, as was the carpet padding. And we know, because Stephen Barrett, the analyst from the lab, told you, the blood matched Larry at an estimated frequency in the nonillions, which is far higher than the billions of people that are on the earth today. So there's a 1 in nonillion chance that that wasn't Larry's DNA. So they took various cuttings from the carpet.
Okay, so
On one of them.
convict Larry. Oh, you already did.
It was Larry plus one other person. On the other one, it was Larry. From the carpet padding.
So you're literally proving it wasn't the defendant.
Larry and one other person. The DNA for the other person was too limited to make a determination. But this makes sense as Larry was the second person to bleed out on the carpet. What else do we know about from the apartment?
Well, there's no question that the
was
murders
interesting.
happened in the apartment.
I'm not saying that everybody that
See,
bought White Castle
The
that weekend
defendant's
was involved
DNA
in
is
this,
nowhere
but I do
around.
think that's interesting. All right, we know that these sheets were off some of the beds, pillowcases off the
No
beds.
question about that.
And we know that a lot of bedding was found in that dumpster, burnt and bloody. What do we know from the dumpster search? We know that Detective Peters, Detective Metzler were faced with a dumpster full of trash. We know that the reason they were looking in dumpsters at all was because the backseat was missing. They wouldn't have gone out just to search for one pink blanket. But fortunately, that's what they found.
We'll get there in a second. So they come to this dumpster, it's full of trash. They call in and say, found it, thinking that some of this was going to be the backseat material. And that's what Detective Tonelli was left with. This search you heard took hours. It took well past midnight. He'd been told they found the back seat, and they did not come back to him at the end of this and say, we found a lot of bloody sheets and blankets and towels, but we didn't find the back seat. He just did not get that information. So when he went to testify, he testified in the probable cause hearing that he believed they had found the back seat. He qualified it. He said, further testing, we're awaiting further testing, but we believe we have the back seat, because that's what he believed at that time. And it was not until he started getting all the reports, and really, he's got other cases going on. I mean, we all wish that we were all straight on the back seat from the very first moment. But yes, he's got other cases going on. We were sitting here. The judge said, what's the biggest thing you've got to bring in? He's speaking from memory about reports that he looks at from time to time, but didn't study up on before every court appearance. And he said, probably the back seat. If he could find the back seat, he would have brought it to you. He would have tested it. But that back seat was never found. And we know what happened to the back seat. Something that police only found out about later at a subsequent interview when Detective Tonelli did say to Anwan, what happened to the back seat? And Anwan told him and tried to show him on his phone, tried to show him where the garage was, but only knew the neighborhood, didn't know the exact location. All right, so we have the dumpster. We have the pink blanket found in the dumpster. As Stephen Barrett told you, from the pink blanket, in two different spots, Maurice's blood was recovered. Now, while we are on the subject of the labs, what else do we know? The tire tracks from the scene were compared to the Mazda's tires. Scott Doyle told you it's really difficult to get a comparison on tires, and in fact, in this case, he was not able to identify or eliminate the Mazda. The shoe prints, he was able to eliminate those shoes from the shoes that Brice Rhodes was arrested in. But we don't know what shoes he was wearing that night. I wouldn't be shocked if they weren't burned in that dumpster.
Whoa.
From
That was
the Mazda.
inappropriate. That was inappropriate.
Swabs were taken from the driver's seat back near the headrest. They were presumptively positive.
That was never
blood,
presented in
and
evidence.
Stephen Barrett was able to find a
That was
perfect
inappropriate.
profile, mixture of at least two individuals. Due to the limited nature, no meaningful comparison could be made. So blood was found in the Mazda. It was not found on the parts near the where the back seat would have been, either because that area was bleached. Two different detectives told you the car smelled heavily of bleach, and the analyst told you that bleach can degrade a sample, or because the blood was on the back seat that got ripped off. Anwan told you that that seat was covered in blood, and that's why Brice Rhodes decided it had to go. That's where the blood was in the car. And the reason that it is not here in these lab reports for analysts to tell you about it is because Brice Rhodes got rid of it.
Or you guys did, one of the two. According to your lead witness.
No,
the lead
Brice Rhodes'
detective,
DNA
you
was
guys
not
had it.
found anywhere but on the gear shift or the steering wheel. That's true. But you know who else's DNA is not anywhere on these lab reports? Anwan Carter and Ja'Cory Taylor. The reason that Rhodes's DNA, Ja'Cory's DNA, Anwan's DNA is not all over the place is because they are not the ones who are bleeding out on all these pieces of evidence.
Well, why was
Larry and Maurice were bleeding on the evidence, and it is their DNA who is found. If
They want to say that because Rhodes' DNA is not on anything, he wasn't involved in this. The same would hold true for Ja'Cory Taylor and Anwan Carter. Their DNA is not on it either.
Except they
We
admitted
know
to
they were
doing it.
involved in it because they told you.
Yeah.
So the same logic does not exonerate him.
No,
from
no,
that
no, no, no,
analysis.
no. Proving a negative. Sorry, nope. That's not how logic works, lady.
The DNA in Rhodes' apartment, the DNA on the blanket in the dumpster, the ripped out back seat, these all corroborate what Anwan Carter and Ja'Cory Taylor told you. Obviously, the defense does not want you to trust them. They asked in opening, why are Taylor and Carter still alive? Well, one, they weren't the people who told their mother. Two, he had learned his lesson and made them get involved in the second one. And three, police put an end to this before anything could happen in future. We don't know what would have happened 2 weeks later. Carter told the truth 2 days after the murder, after initially not, but then talking to his mother and sister. Do you think that his mother and sister came in there and said, I've got an idea. Why don't you tell them that you're involved? Why don't you tell them that you stabbed them too? That's a great idea. No, they went in there and said, tell the truth. If this were not the truth, he would have said, I was just an eyewitness. I just saw it happen. I didn't do anything. The fact that Carter gave them so much information that led to his own conviction for facilitation to murder corroborates his statement.
Yeah, exactly.
Corey, the
He
next
admitted
day, May 25th, said he didn't know anything about it. I'm sorry, there's the Melissa.
Prosecution gets the last word.
What do you all notice about the car?
Hold on. Why didn't you and Anwan just leave during the night?
So I did.
Why didn't you? Well, he was gone.
I was too scared to be honest. I wasn't even in my right state of mind. I mean, me personally, I never seen, I never witnessed a scene like that in my life. Okay. I don't know why we didn't leave them, to be honest. I just got scared. Just did what he told us to do.
So 2 days after this whole situation, he's forced to participate in the murder, scared, not leaving. 2 days later, he's in an interview room, alone, no father, no mother, no one to talk to, knowing that the last people who told what had happened had ended up stabbed multiple times. So he told police he didn't know what happened. It was not until later, when he had been in custody, ironically safe from this whole situation, until he had an attorney, until he had time to think about this, that he came forward. I'm gonna return to the slide that I had skipped. This is back to the back seat. I just wanted to play this for you in case you missed it. Oops.
What do you all notice about the car? The back seat. And so, how was that handled? Cut the back seat up. And who cut the back seat up? What did he do with the back seat after he cut it out?
So that's why we don't have the back seat. Okay, hold on. I'll get to this in 1 second. But first I wanted to say, if you don't like the plea deals I did with these co-defendants, that's fine. I mean, that's my signature right there.
That's fine.
Right on the back of your jury forms. I think they got too much time. I don't think they got enough time. I don't think you should have amended down. Well, I don't know how you feel about this. So you can call me up later, look up my office number, call my office. But if you believe what they told you, if you believe that he's guilty beyond a reasonable doubt, then your feelings about this plea deal don't affect your verdict. I had to make a decision on what to do with Ja'Cory Taylor and Anwan Carter. And one of the things that I knew was important was getting you all the evidence that you heard in this courtroom. And these are the sorts of things, sorts of decisions that we have to make in courtrooms all the time. Because the witnesses to crimes are often also the participants in crimes. So if you are mad at what I did, that is fine, let me know. But that doesn't mean that Brice Rhodes is not guilty of murder. And so let us talk about what you need to find under the instructions.
Ugh.
So it's
Oh, hang on, I got a delivery at the door.
it's actually very logical. You go
I'll
through
be
page
back.
by page. You start with 1A, and then the language for murder and the language for manslaughter second is the same for each victim. I just picked Maurice here because he's the one in the middle. And what's in parentheses is the things that changed from instruction to instruction. So for Christopher Jones's murder, it says the 4th day of May, 2016, and shooting him with a gun. Obviously for Larry's, instead of Maurice, it says Larry, but the date and the manner are the same. But so for each count of murder, your analysis is the same. You shall find the defendant guilty if you believe beyond a reasonable doubt that in Jefferson County, the instructions actually say in this county, but it's obviously Jefferson County. You saw the map. On or about the dates in question, that he killed each victim by himself or in complicity with others. And we've gone over all that. By shooting Christopher Jones, by stabbing Maurice and Larry. And that in so doing, he caused the death of each of them intentionally. And there's going to be an or that I'll flip to in just a second, or wantonly. You know it was intentional because he planned it, he premeditated it, he told the witnesses in advance that he was going to do it, and then he did it. But let's go to the or that in so doing, he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death under circumstances manifesting extreme indifference to human life. So I'm going to flip up to the definition of intentional and wanton. Intentional is what you think it is, when the objective is to cause that result, in this case being death. Wantonly is when someone is aware of and consciously disregards a risk, a substantial and unjustifiable risk that the result will occur. And the risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct, standard of care that a reasonable person.
Buffering, really? Really? All right. Oh, what did we get a sidebar for? We missed, she said something and that prompted something sidebar-ish. Wow. Well, this is bad. I mean, just, ugh. Ick. No, I was getting a delivery, like a giant bottle of honey for making Christmas dinner. Got to make some honey butter for some cornbread and some honey glazed ham. We do have one super chat from Ben there, done that, $20. Thank you so much. This is for your suffering. I mean, your coverage. This is always a rough day. The jury instruction day is a rough day. Ordinarily, closing arguments aren't a rough day, but this has been just like really, really undynamic from both sides. I think the defense made some good points, just in an incredibly boring way. And I can't really stay focused on what the prosecutor is saying because she's just mayonnaise, just
So if you believe that he's driving down the road, shooting his gun, not specifically intending to hit and kill Christopher
I'm
Jones.
sorry, can you all approach for just a moment?
So you can get your ass back here. Okay, so this is the judge calling people back on her own. Let's see if we can figure out why, depending on what they say. She could be waving her arms around saying, hey, when are we going to wrap this up? And I hope they wrap it up soon. 'Cause I'm literally up against here's what's going to happen. It's what, 5:30 there. I don't know how long they'll deliberate, but I'll keep watching. And if they come back with a verdict, I'll either do it or I won't. How's how's that for a stay? I'll either do it or I won't. What I'm thinking, what I'm planning is I'll keep monitoring the deal, and if they do come back with a verdict, I'll stream from my office. But if I'm in a meeting or I
Sorry,
can't
to
get
make
away,
it clear, I'm giving you an example of how this could be a wanton murder. I'm not saying this is the only way it could be a wanton murder. So for an example,
if I can't, then I won't.
because
Well,
wantonly
it'll do it
means that somebody is aware of,
tomorrow.
okay, first of all, wantonly is not intentional. So that's what I'm saying. It's like we've moved past you. This is only in the circumstance where y'all think it's not intentional. So it would be wanton if you believe he's aware of and consciously disregards a risk. So he's aware that shooting somebody is dangerous. He consciously disregards the risk that shooting out the window he could hit a passerby. And that the risk of him hitting a passerby is of such nature and degree that disregard thereof constitutes a gross deviation from what a reasonable person would do. So if you think a reasonable person would know, I shouldn't shoot out the window because I might hit somebody, and that disregarding that is a gross deviation from reasonable care, and that he understood that risk was there and he consciously disregarded it, that would be an example of a wanton murder. So just to go back to this, if you believe that he intentionally murdered Christopher Jones and or Maurice Gordon and or Larry Ordway, or you believe that he wantonly murdered them, so the same with the stabbings, like that he was engaging in conduct that he didn't intend to cause murder, but it was such conduct that one would know could cause murder, that he knew it could cause murder and that he did it anyway, and a reasonable person wouldn't continuing to stab somebody. That would be an example of a wanton murder with a knife in this circumstance. So if
Sorry,
you
I've been
believe that
muted.
he intentionally murdered,
I was just saying she's
let's
lost
just
her
say
own
Maurice,
train
that
of
he
thought at
intentionally
this
murdered
point.
Maurice.
She's so boring and
Or
dull. She
some
lost
of you
her own
believe that
train
he
of thought,
wantonly
and she's
murdered
just spewing
Maurice.
word salad at this
All
point.
you have, because you see that this is an or situation. As long as all of you believe.
Mm-hmm. Yeah, she's off in the weeds. She's wandered off into like nutty town. All right, I know you're probably all missing this, so I'll do it for you. There. Just didn't want you to miss some of the judges coughing. Yeah, she needs to wrap this up because she's making it worse. She's lost her own train of thought. She's just spewing shit, which is leading her to say shit she shouldn't be saying.
So as long as you all believe that it was intentional or wasn't, then all of you believe it was murder. Obviously beyond a reasonable doubt. So to start at the top, because I know this is really complicated, but I don't.
It's really
want
not.
to think that I could have explained it better, and I just failed to.
You could
So,
have. You did.
in Jefferson County, on the date in question, by himself or in complicity with others, he killed Maurice Gordon by stabbing him with a knife. And we went over the complicity instruction earlier. That it was intentional or that it was wanton. So as long as you all agree that it was murder, then you can sign the verdict form for murder.
And
Now,
what if they
there
don't
is
agree it's murder?
a sub part down here in your instruction for example on page 14. So the foreperson would sign either not guilty or guilty. So that part, we have to sign one if it's not guilty or guilty. Then, if you found him guilty of murder, you add in there if you agreed all 12 that it was intentional murder. So your choices on each of the murders is either not guilty, no more signatures, or guilty, and then maybe you all agree it's intentional and you sign there, or you don't all agree it's intentional and you don't sign there. So one of these top two has to have a signature, and then it's up to you as to the bottom whether it is in agreement that it's intentional. I apologize that our state gives, these are the instructions that we have. All right, so those are for each of the counts of murder. Now, if you don't find him guilty of murder, you go on to manslaughter in the second degree. If you do find him guilty of murder, you skip the manslaughter in the second degree. So it's murder, or it's manslaughter, or obviously not guilty, but you wouldn't find him guilty of murder and manslaughter for the same victim. It's one or the other. Now, you only go to manslaughter in the second degree if you have found him not guilty of murder. So if you do, you will see that the main difference is that there's no intentional on there.
This is way messy.
And that in the second clause, it just says that he was acting wantonly. So that A is he killed Maurice Gordon by himself or in complicity by stabbing him with a knife. And B, that in doing so, he was acting wantonly. So it omits the intentional, and it omits the grave risk of death to another, etc. But you don't get there unless you found him not guilty of murder. And I believe, obviously, that we have proven, for all the reasons I've stated, that this was an intentional murder. Now, there are 3 more charges. We have abuse of a corpse. And as you can see, that instruction defines each of the elements as on the 22nd day of May, 2016, he, alone or in complicity, placed the body of Maurice and the body of Larry in a yard off an alley and attempted to burn it, that he had no legal authority to do so, and that in so doing, he treated
and no legal authority
in a way
to
that would
burn a
outrage
body.
normal family sensibilities. I think that's obvious. The other, well, here is Ja'Cory describing his knowledge of this. And he told you the bodies were burned? Did he tell you where he dumped them? West End somewhere. Then the last one we haven't discussed is tampering with physical evidence. You have to find that on May 22nd, he, acting alone or in complicity, destroyed, mutilated, concealed, removed, or altered items from the North Height address, including a pink blanket or the knife or the back seat. If you believe that any of those items were tampered with, then this would come into play. That he did so because he believed that an official proceeding may be pending. That would be the investigation and prosecution. And that he did so with the intent to impair the availability, so that he burned the bloody clothing so that police couldn't find them and that we couldn't bring them into this courtroom. He ripped out the back seat so that police couldn't test it. We couldn't bring it into this courtroom.
Who's driving the car? Yeah, where do you go to?
We went to like different houses. Houses on fire.
Why different dumpsters?
Just to spread evidence.
What type of evidence?
It could have been clothes, it could have been, sheets on it, evidence.
And was it stuff with blood on it? What did you all do with that stuff?
It was took to a dumpster and they burned the stuff up.
And that is how you know he is guilty of tampering with physical evidence. I have one last slide to show you.
Presented, all was pretty much murder. Just
Ja'Cory Taylor was 17 when this happened. He's 25 today. Anwan Carter was 15 when it happened. He's 22 today. They've both been to prison. They've both paid a heavy price for not having the courage, confidence to stand up to that man. Nothing compared to the price paid by the victims, obviously,
That was
but
a
a price
weird noise.
nonetheless. Brice Rhodes preyed on this group of children. He killed an innocent man for no reason. Then he killed 2 children for a horrible reason, because they confided in their mother. There is no other explanation, no other possible motive or defendant
Really?
to explain why those children were murdered so horrifically. Please bring this 7-year nightmare to an end and find Brice Rhodes guilty of these murders. Thank you.
Wow.
Ladies and gentlemen, at this time, we are going to draw who our random jurors will be. Counsel, would you all mind to come up?
Rando juror. Wow. This could go so much either way. I mean, she could have talked herself out of a conviction on several of those charges just by being that bored, that confusing, that disjointed, and that boring. Not only was she bored, but she was boring. I mean, she could easily have just lost the jury and talked herself out of some convictions there. That was, especially when she got lost at the end and was just like wandering around in the weeds somewhere. Will Call Magic says, I'm going to not guilty now after all this talking. Seems circumstantial. So that's what I mean. She explained far too much.
All right, I'm going to tell you who the alternate jurors are. I'm sorry, John, would you mind to move that easel? All right, so I have drawn randomly, literally out of a glasses case, our 2 alternate jurors. Those 2 of you, I'm going to ask you to remain seated. The rest of you will go with Deputy Mills back to the deliberation room. And Deputy Mills, I just need to swear you, please. Do you swear that you will keep the jurors together and allow no person to speak to or communicate with them on any subject connected with the trial, and you will not do so yourself? All right, thank you. So the 2 jurors who will not be going with Deputy Mills are a juror ending in 8801 and juror ending in 9462. So if you all could just stay here, please. The rest of you will follow Deputy Mills.
Well, congratulations for the judge for just not reading out their names. And I see that's not a camouflage thing; it's a flower pattern.
Your notepads have to stay here.
So the only thing we can take is this. Correct.
Cannot take your notepad with you. I said that. Yeah, sorry. I did say that at the beginning as well.
They don't get to keep their notepads as a
just
memento of
remember,
their
you'll
time
have
on
one
the jury.
copy that you'll have the 4-person sign. All right, for the 2 alternates, can you all come up
Why is
here?
the
and
sheriff got
Counsel,
his
you can come up
AirPods
as
on?
well. The camera will need to go off now.
Okay. Raven says, this is why I dislike you yelling about stuff like what happened with the grand jury. I get stuff mixed up and now I can't tell from the evidence what is right. Well, see that yelling about things like that happen in front of the grand jury is linked to this case. It undermines the credibility of the police officer when he's lying to them. It undermines the entire indictment of the defendant for the crimes, because the basis on which he was indicted was in part a gigantic lie by the police department. That's why it's that's why it's important, because they put him on the stand and they say, oh, hey, this is what I'm testifying to now, and they go, well, look, you lied about this before, so why should we trust you now? I will never stop ranting when shit like this happens. Oh Lord. All right, let's see here. Just reading through chat. All right, well, they're doing something. We'll just wait for them to do it, and I have 16 minutes left, so whatever's going to happen in the next 16 minutes is going to happen. That was deep, wasn't it? Whatever shall happen in the near future would happen in the near future.
All right.
Yeah, thank you.
All right, so we are going to go ahead and let you all go since I have your contact information.
Okay.
But like I said, there's a slight chance, something could go wrong. We could need one of you to come back.
Oh,
So in the
never mind.
meantime,
Letting
you
the jurors
remain
go.
under oath as a juror in this case, and you remain subject to the admonition, which I'm going to read one more time just to be clear.
Letting the alternates
You
go.
must decide this case based solely on the evidence presented within the four
No
walls of
such
the
luck for
courtroom.
us. We've got to
You
stick
must not use
around.
internet search engines,
And
websites,
by us, I
blog,
mean
or any other
you.
electronic tools to conduct any research, post information, or help you deliberate. During the course of the deliberations, do not communicate online with anyone connected to the trial, including witnesses, lawyers, other jurors, experts. And if you accidentally encounter any information about the case from any source, immediately bring it to the attention of the court. The other thing that I'm going to do is, because I think what I'm probably going to do is just call you all when we have a verdict, since I've got your information, and then you'll know. I will call you and say, hey, we have a verdict. You're officially relieved from duty. And then if you want to know what it was, I can share that with you as well. Okay. All right. So you all are free to go. And the next time you hear from me will hopefully be me telling you that we have a verdict and will not need you. Okay. All right. Thank you.
Thank you.
I'm getting antsy here. I'm coming down to the wire.
And you all do not need to go to the jury pool room. You can go straight on out. Thank you. Do we have anybody that might be able to just kind of watch them walk to their car?
What do you need?
I'm wondering if we have somebody that can just kind of observe them walk to their car.
Sure, which ones?
The people who just left.
Okay. I'll have to catch up with
The jurors,
Okay,
Jimmy.
well, then let's go. I mean, you all also have walkie-talkies. Maybe you could call down to the first floor or something.
This guy ain't the smartest tool in the shed. Can you walk the jurors out to the car? What? Out to the car? Who? The ones that just left. I gotta catch up with them.
All right, Mr. Griffith and come up. I have your all's phone numbers. I do not have your co-counsel's phone numbers. I have Mr. Cunningham's. But typically what I'll do is send a group text to all of the attorneys when there's either a verdict or a question.
Traditionally, what happens if Mr. Rhodes is to stay in the courtroom? Does he go back?
No, we'll let him go back, We'll let him stay up here for a while. Who knows? We might get a verdict pretty soon. But he.
Oh my God, Judge,
Doesn't
come
matter,
on.
honestly.
I know you're not saying how the verdict will be, but
Okay. I mean, the jail's not going to deliver food on demand, Mr. Griffiths. I don't know if you've met our jail, but you all are welcome to get him food.
Great.
Honestly, I shouldn't say that. They probably would.
No, I totally.
But I bet Mr. Rhodes would. Yeah, I know. They wouldn't be happy about it. That's for sure. Thank you.
well, I think we've said everything important that needs to be said.
All right. Tie first 433, 434. I see it now.
Sorry, it's a new
Okay.
number.
It's okay. I got it. I'm just going to go ahead and put you all in here.
Well, all right. I guess we're done. Later days, Purple Haze, Judge, and why is never mind. I was going to make a lewd comment about this, about the Commonwealth seal, but I won't. All right. Well, it's big in me. That was rough. That was a long day. How long was that? That was 5 hours and 17 minutes. Great. Well, that's where we are. That's what we did. We got through jury instructions. We got through closing arguments, and we're under deliberation right now. Those were not good closings by either side. As bad as the defense was, I think he did a better job than the prosecution. The prosecutor was just all over the place. And if she said anything that linked him to the murders, I don't know what it was. To the murder of the two kids. That's not good. That's not how you do closings. That's just not good for either side. But they are in deliberations. And so what I'm going to do is I'm going to get ready. I'm going to head out to the office and I'll be watching to see if they do anything. If they don't come back with a verdict today, then I won't stream anything about it and we'll just pick it up tomorrow. If they do come back with a verdict, I'll try to jump on and do it live. If I can't do it live, we'll do it tomorrow at the regular streams time. So that's what we're going to be doing. Yeah. Can't really think of anything else. We have our little poll. Let's see, how did our poll end? The like and subscribe poll for the day was, has the prosecution proven guilt beyond a reasonable doubt? 53% said yes, 47% said no. That's a dead heat, both within the margin of error. So, right, that's the end of that poll. I guess we'll see you when we see you. How's that? Stay tuned to check out for Twitter. Check out for scheduled videos on YouTube. We'll have information there. Be funny if they just came like right back right now. Anything else? Guess not. Well, that wraps up my day then. It's 8 a.m. here. Time for me to switch clothes and jump in. Yeah, well, Jake, 80 $1, don't have to shave. We got that taken care of yesterday. We're still good in the shaving department. Showered before I came here. Don't have to take a dump. And the shampoo is not something that I ever really worry about. So I'm good to go. Just change clothes and head on out the door. Time to sleep. No, it's time to go to work. It's 8 a.m. It's work time. I slept like 6 hours. I usually sleep 4.5, 5 hours a night. I actually slept 6 hours. I slept like more before this show than I normally sleep on a normal day. So I'm extra good. And depending on what happens here, what happens here in the next couple of hours with this trial will determine what I stream tomorrow. So we'll just have to take care. This is a rockin' sweater from the Aran Islands in Ireland, and yeah, And my hat came from the same place too. I have like a blue cardigan from there that I wear at work and a bunch of other stuff, gloves. My scarf is from there too. But anyway, righto, that's it. We're gonna wrap this up. I'm gonna get out of here. Mods, thank you, especially those of you that stayed up all night with me for some reason. Thank you so much, mods. Thank you so much. Oh, and mods, we need to start doing stuff for It's a Very Moddy Christmas, which I believe will probably go on next Friday evening at probably around 6 or 7 p.m. Eastern. This Friday. So this Friday, 6 or 7 p.m. Eastern will probably be our Very Moddy Christmas for a couple of hours. Mods, if you can check with amongst each other and let each other know, I'll be setting it up and sending out a link very, very soon. We get all of our mods there that want to come on and say hi to all of you. And let's see. But Chappie says Jeff's going to be dragging at 5:30 his time. Well, that's the beauty. I'll come home and I'll go right to sleep, and then I'll sleep until it's time to stream. So I'll get at least 3 hours in before it's normal stream time. So we'll be good. Mods, again, thank you so much for everybody. Chat, thank you for being here. All 400 and some odd of you. We've dropped down to about 300. What the hell's going on in lawn crime? Nothing. Okay. I thought something was happening already. I was like, what? Couldn't do this without you guys. You guys are awesome. We're down about 322 now, but we did get almost 500 likes, 492. And our very last super chat of the day, been there, done that, sent us over Doggo Cam activation, but Doggo Cam isn't here, so we'll have to work out something for later, I think, because we achieved Doggo Cam today, just barely, but they're all in the living room sleeping. Thanks for the support, guys. That's it. We're pulling the ripcord. We're out of here. we're done. So until we meet again, whether it's in an hour, 2 hours, or 12 or 16 hours, or whatever the hell we are, we'll see you. Until then, just make sure that whatever you do, however you do it with, and however good it feels, you are enjoying your legal vices. Larax saying peace out.